Withdraw the same. Withdraw the same. Let's come to more next.
Mention that CS number 238 of 2019. Perhaps I'm your lordship signed, but this was a decree on compromise asked by your lordship. The decree has been drawn up by the department. The decree is not being released. There is some difficulty that it is not being released, perhaps because there is the original terms of settlement which was filed by us. That has to be affixed with the decree. Perhaps that is in court. If that is the complaint.
Tomorrow.
Depositing their fees of Helua, who has been appointed by High
When the date is fixed.
It has been its minor last order has been passed in 18th July 2024. And
The notice come on the name.
I have some notice.
Next week at the date. Yes.
Minus the source of the song by authority 16th of January 2025, allowing my amendment applications. Sure, when this is filed by April 2024. Rather, I got certified boxes 17th of February. My signature
Extension.
is extensible tomorrow.
Tomorrow it will come in the list.
Okay.
Lordship, with the file instruction, this matter I have registered for notice lordship. Matter was asked my lord's list on 24th lordship for hearing. The my lord's court ever decide on such date lordship. Matter is not in the list.
Check it. Check it. It will come in the list. We'll do the site.
I am appearing for the defendant numbers 1, 2, and 3. Am I audible to my lord? I am appearing for the defendant
Yes.
numbers 1, 2, and 3. Yes,
Yes.
my lord, I've been served notice, my lord. I believe the plaintiff is seeking adjournment. I have no objection. I bow down to any other date by my lord.
25-5, 25-3.
Obliged, my lord.
My lord's mentioning. My lord said, I have applied the affidavit of service copy GL number 5, 2024, CS 31, 2017, 2024. But on query of the department, file is non-traceable. File is when the next day fixed. 13. Come on 13th, I will check it.
Just like commerce eviction, item number 1. I'm the commissioner. We have to get this matter. Just the
Extension of time.
Yes, madam, but before then, only asked yes, time frame maybe
90 days it was there.
yes, madam.
but in the meantime, the father of the learned advocate, using the prayer of 2 and 3, I feel that
On prayer of the learned advocate commissioner, time is extended till the returnable date, namely 22nd April.
item number 2. Item number 2 is challenge the company is for the plaintiff.
Then I have to verify.
Her father had a medical emergency this morning. So
That is all right, look, I can't stand in the way.
tomorrow.
Only that, my understanding with it, its order was to make it compliant regarding the commercial code. So that probably has not been done, and if it has been done, I have not been served with a copy of the amended page, the statement of.
It will be adjourned for some days.
Yes,
Well done.
by pass on to adjourn it to another date.
Tomorrow.
Tomorrow is the date fixed.
Today is item number 2, in my lord.
Yes. Then on prayer of the learned counsel for the plaintiff. Plaintiff, the suit is adjourned to 14th March is okay?
Yes. So,
She has come. She has come.
yes,
So 14 possibly.
I'm
No, not 14.
well, it my lords will consider 18th March.
No, not 18.
Very good. Any day thereafter, because I understand it will take some time to complete the compliances.
19th March.
Obliged. Obliged.
Item number 3.
Item number 3, I'm appearing for the plaintiff, my lord.
The affidavit of admission denial. Admission denial has to be completed. Everything else.
Complete.
Judges brief.
The plaintiff was supposed to.
Judges brief.
My lord, the defendants have not supplied with the copies. That's why the judge's brief is not ready, my lord. The
But-
affidavit of admission denial is also pending, my lord. On the last occasion, they did not appear. I'm just seeking time to finish the affidavit of admission denial and file the judge's brief on the next day. Which will kindly give me a
Admission and denial of document is not complete and judges brief of document is yet to be filed. The same shall be filed on or before the returnable date. Parties shall take necessary steps in this regard. The suit will appear in the list for framing of issues on 24th March
my lord, grateful.
or some more days.
My 24th March is, my lord, enough time for file. I'm grateful, my lord.
Item number 4, 5, and 6. Item number 4, 5, and 6. They have to be short possible. Yes, yes. Outside the panel, you don't for direct football. This one, they are very short possible.
What was the last order? Payment of money.
Yes, madam. The check was handed over, madam, for as well as cost of preparation of textbooks. That time for the deposit, madam, in terms of the launch sort of was extended for the last day.
No further time should be allowed.
That's it. And also, there is no further rental.
Today, check is handed over to Mr. Sinha for preparation of paperwork. You, if they say, affidavit reply, who is to file affidavit reply?
My lord, whether on item number 4, and we are filing an indemnity application, my lord, GA 1. We are supposed to file affidavit in reply, my lord.
Affidavit reply in so far as GA.com 1 of 24 is concerned.
Yes, my lord. My lord, we have served the advance copy of affidavit in reply, my lord. So what happens is like our client is based in Kerala, my lord. So we have a debit account on time, my lord. Kindly grant some time. We have already served them the advance copy of the affidavit. Whenever your lordship takes up the execution application, I have not but my lord's order, my lord, for the first time, we don't price.
The learned counsel for the intervener prays for extension of time to file affidavit in reply in GA.com 1 of 24. Time is extended till the returnable date to file affidavit in reply. Yes, so far as the other matter is concerned.
The other matter, my lord, is my lord, comply with the direction for payment. First,
It was handed over.
no, first, that was for question. That is it. First, that was for question. May I have your lordship? May lordship kindly have a look at first paragraph of your lordship's order
So there was previously there was an order passed for
Yes.
depositing money.
for 26th September and 3rd October. That was your lordship's order for deposit of the security amount.
Deposit should be made and bank guarantee should be furnished.
For that, they prayed for extension on the last day. So, your lordship, on the first paragraph, kindly see of the prayer of Mr. Sinha, learned counsel for the award date as well as the date. Time is extended till the returnable date for compliance with the order dated 26th September and 3rd October. No further time shall be allowed. The time for depositing the money.
The process deposits consideration, this particular company
I
has
am
worked for a long time and this is now got into liquidation. My understanding is that they have already paid for the money to be supplied by the finance department of the state. It's taken some time.
Time will kindly
Here-
take from where it is started.
We're an item on that.
So let us, may I suggest, why
Your lordship-
execution application is already in the list.
item number 6, let us get some order at least for in the execution.
And I have to modify this order. That I cannot.
That would be on an oral prayer, this cannot be done. Your Lordship will take up money.
Who will pay the money?
We are not required to deposit the money.
West Bengal Sugar Industries Development Corporation.
That's a Sikh company. So that company doesn't have any money.
There's no order of a Sikh company. My learned friend is.
Very financial, yes. So we have paid before the finance department. It is taking some time, Your Lordship. We can come up with an application next week.
No, but
Saying what is the status? Yes.
No, you have to make payment. There is an order, you have to comply with this. Either you have to go to appeal against the order for setting aside, or he has to
At
modification.
least for the deposit.
So long as this order is subsisting, you have to comply with it.
yes, kindly have a look at my tabular statement.
We have tried to get the approval for the finance department. It is yes to us.
There is a
So give me a date. Let me one thing be clear. Give me a date tentatively, and copy of this order will be sent to the finance secretary.
Yes, sir. I think
Or the finance secretary shall be called here.
yes, sir. I think that will be something which otherwise it is absolutely absolutely dependent on the finance department. This particular company does not have any fund. Communication or it will help.
A further extension of time is prayed for compliance with order dated 26 September 2024. Read with the order dated 3rd October 2024. The learned counsel for the state candidly submitted that they are trying their level best to get sanction from the finance department, but the same sanction is yet to be done. Considering the fact that the government department have to face number of impediments, time is extended till 4th April 2024. 25 for compliance with the order as aforesaid. The finance secretary, not finance secretary. There are a number of finance secretaries.
Let me say, chief secretary.
But the principal secretary, finance department shall ensure that proper order be passed, and the order dated 26 September 2024 as well as order dated 3rd October 2024 be complied with. In case of failure of which, necessary order shall be passed.
But in the execution,
Copy of this order may be communicated to the Principal Secretary, Finance Department, Government of West Bengal. The matter will appear in the list on 4th April.
only thing I was saying this one.
Richard said, sometimes Saridon works better than antibiotic.
I know, but the
If it's
problem
not working, then antibiotic will give.
is that by lapse of time, the stakeholder may become sick. Then even the antibiotic may not work for the stakeholder. Kindly balance it. I am not saying
When the execution proceeding is there,
it is already item number 6, item number 5. But then in that case, kindly see, they have already disclosed as part of their section 36 that they have certain amount in the bank. But let that amount be at least kept. They should not operate without keeping apart.
where is that? Where is that? Please?
If your Lordship kindly pay a section.
ECCOM on the review.
ECCOM is there, but this document is part of their annexure to the section 34. AP number.
You do one thing.
Kindly take page 255 once.
You do one thing, come with an affidavit, I'll pass order in a meantime, before 4th April. I will
Your
pass
Lordship will keep my EC in the meantime or any other day, your Lordship will give.
I passed the order in AP 37.
No, your Lordship. Yes, AP 37.
AP 37. So far as ECCOM 132 of 2004 is concerned, comma, the same shall appear in the list. देखिए बोलो 10th March. Epicom 6/15/2024 as well as Epicom 37 of 23 shall appear in the list on 4th April.
But they should not say, my lord, that says that your lordship has already extended the time for deposit. Let it
You come on that date. I'm concerned, will be concerned with the execution proceeding only. Necessary order, if prayed for, can be considered. I will say I will pass, will be considered.
For arguments, I cannot eat.
You are here.
Yes,
You are arguing for?
I am appealing for the plaintiff, the defendant and for the defendant. I was the defendant. Mr. Shah is from his your lordship. Well, this claim arises out of contract of insurance. I think this.
Oh, sorry, IRC.
Yes. The contract of insurance. Well, the insurance item was a mobile harbor crane. Well, this mobile harbor crane caught fire. It was totally damaged. There was an inspection made to whether asset as to whether it could be repaired. They found that the cost of repair could exceed the cost of manual damage. Well, ultimately, it was accepted as manual totally damaged, and manual therefore the insurable risk became a right. Now, so far as this is concerned, that there is no allegation of arson. This is not very important. There is no allegation of arson. The contract of insurance, says that ultimately the insured must benefit from the policy, except in the case of exclusion clauses. What my learned friends have done is to proceed to repudiate the claim. Now, to cut a long story short, of course, there is A, no allegation of arson, B, acceptance of the fire accidents, C, devastation of the machinery, etc. Now, therefore, there were
Certain facts are admitted.
Yes.
The machine was stationed there.
Yes.
The tower crane was stationed there.
That's right.
It caught fire.
That's right.
Issue is whether it was caught by negligence or it was caught by accident.
No, negligence cannot be the issue. Well, if your lordship now looks at the insurance policy, two propositions of law which are very fundamental. Exclusion clauses in an insurance contract are to be very strictly construed. That is whether Supreme Court I should show your lordship the judgment state.
Where is the policy?
Please come to the policy under the policy is page 78 in Judges Brief Volume 1.
Is it exhibited?
Yes, it's one. Please see serial number 4.
Page
78.
78
of the volume 1 of the Judges Brief.
No.
The contractor's plant and
Yes,
machinery insurance policy.
Yes.
Yes. Nevertheless, this is the insurance policy. I will not trouble your lordship with the details. But there were two cranes which were insured. Nevertheless, so far as the standard terms of the policy are concerned, that your lordship will find from page 86. Let me just read this. Whereas the insured named in the schedule hereto by a proposal and a declaration which shall be the basis of this contract is deemed to incorporate such and such, then kindly see the last 3 lines.
Exceptions.
No, before that, insurance in respect of accident or damage occurring during the period of insurance. Just before the now this policy insurance witness. But the insurance is for accident or damage occurring during the period of insurance stated in schedule.
Which are you referring to? Which part?
Your lordship sees in bold there is now this policy of insurance witness.
Yes.
Just 3 lines before that.
Again,
premium as consideration for such insurance in respect of accident or damage occurring during the period of insurance stated in the schedule or during any subsequent period for which the policy pays.
Subject to the terms, exceptions, exclusions,
That's it.
so and
Now,
so. The company will at its own option by payment, reinstatement, repair, so and so.
Now, kindly come to the exceptions. Nevertheless, my learned friends have relied on the exception O, page 87. Page 87, exception O. That is what has been referred to as the cause for the
I have marked someone possibly not. Exhibit the
This was possibly not pointed out to your lordship. Subject of course preparation by my learned friends.
Can you take it back? If you can find it out.
Nevertheless, your lordship has seen the exceptions. Well, there at page 86.
Loss or damage directly or indirectly caused or arising out of aggravated by willful act or willful negligence.
Nevertheless, the words are loss or damage directly or indirectly caused or arising out of what? Aggravated by willful act or willful negligence. So, the act has to be a willful act or negligence has to be a willful negligence. Your lordships have interpreted the term willful to be deliberate. Which would infer that I have deliberately caused the mistake. That would also indicate arson. There is no allegation of arson. So, my learned friends, to avoid the policy, will have to make out a case that what I have done or not done is willful act, which must be a positive act, or willful negligence, which will be a deliberate negligence. Now, with the greatest respect, if your lordship sees the written statement that has been filed in suit, there is no allegation that I have willfully done something or willfully abstained from doing something. And this goes to the root of the matter. Now, we'll kindly have a look at another clause, which is clause 5A, which has also been referred to that your lordship will find at page 90. Obligations of the insured. The insured shall take all reasonable steps to maintain the insured property in efficient working order and to ensure that no item is habitually or intentionally overloaded. The insured shall fully observe the manufacturer's instructions for operating, inspection and overhaul, as well as government, statutory, municipal and other binding regulations in force concerning the operation and maintenance of the insured plant and machinery. This is an obligation that is imposed on the insured. I have to therefore take reasonable steps to maintain the property in efficient working order. I have to ensure that it is not habitually or intentionally overloaded. I have to ensure that the manufacturer's instructions with regard to operation, inspection and overhaul are followed. I have to ensure that government, statutory, municipal and other regulations in force concerning the operation and maintenance of the plant and machinery is followed. There is again no allegation that any of these have not been followed. Now, let me straight away take your lordship to the repudiation letter. Please have a look at page 793, that is in Judges Plea, volume 5, 739. I'm sorry. You take the process. Now, may I read this? The second paragraph, if Lordship will see.
Page.
This is page 739. May I raise this? Well, I'll read this one that proposing a little bit slowly. This is reference to the caption claim lodged with us by you and our observations on your claim on receipt of final survey report along with annexure including forensic report issued by Messrs. Screen Fact Services, etc. On going through the final survey report, we observe that surveyor has considered the inferences and observations of the report of forensic expert Messrs. Screen Fact Services Private Limited, dated 9th August 2019, and has attributed the prime cause of loss due to negligence. Let kindly mark there is no willful negligence, due to negligence on the part of the insured in regard to non-compliance of safety norms. But this is not government safety norms. This is not the manufacturer's safety norm. Non-compliance of safety norms required for the pump, not of the machine, to be used in such operation in the said survey. Then, accordingly, the surveyor has recommended for repudiation of the claim and the decision.
This is the exhibit. It is exhibited.
Yes, madam, this is the exhibit. Then, all the documents the judge is correct. Accordingly, the surveyor has recommended for repudiation of the claim and the decision regarding the inadmissibility of the claim is based on exception of the
When you file your notes of argument, you refer the exhibit number. Suppose when you refer to the argument this one, exhibit number is fine.
I understand. Now, this is primarily, if I may confine myself to just these two paragraphs first. They say that the prime cause of loss is due to negligence. Now,
Your point is there is no willful negligence.
No willful. Well, there is no willful act. So there is no positive act. And there is no willful negligence. And so far as this is concerned, loss is due to negligence. Negligence in what? In non-compliance of safety norms. Safety norms for what? Required to be used for the pump, not for the machine. Pump to be used in such operation. But this is the operation of feeding oil into the machine. Now, so far as the pump is concerned, it is not the machine. Your Lordship has seen clause 5A. But 5A conditions are saying that you have to comply with regular maintenance of the machine, operation of the machine, and you have to also ensure that the operators, operating instructions are, I'm sorry,
5A.
manufacturers operating instructions.
You are referring to 5A.
That's right. 5A, at page 90.
Reasonable steps.
But I shall read it again. Reasonable steps to maintain the insured property in efficient working order. Well, no allegation about that. To ensure that no item is habitually or intentionally overlooked. No allegation. Insured shall fully observe manufacturer's instructions for operating, inspection and overhaul. Well, no allegation that manufacturer's instructions have not been followed. As well as government, statutory, municipal, other binding regulations enforced concerning operational activities. No allegation that government regulations have not. They merely say that you have not followed the standard operating procedure with regard to the operation of the pump. Now, what is the standard operating procedure with regard to operation of pumps? Nowhere mentioned. Well, coming back to the letter of repudiation, because this goes to the root of the matter. Well, I can argue for hours. Well, why my learned friends' arguments are completely bogus, without basis. But going to the root of the contract, if the insurance contract is a contract that must ultimately lead to a situation where the insured is benefited and not deprived of his rights under the policy on specious fee.
Pump is not the insured.
Pump is not insured. Pump is a device through which there is a vehicle which comes.
Pump belongs to whom? Petrol pump.
No, it belongs to the dispensing authority.
Dispensing authority, yes.
Now, what happens? There is a fuel tank that comes, fuel truck. well, those Indian oil and other oil trucks, tankers, they come. Well, there is a pipe that goes, fitted into a pump. That pump pumps the oil into the train. So, the pump is not my. Well, in any case, it does not fall within either 5A or clause M of clause O of the exception. And there is no allegation either in the surveyor's report or in the report of the forensic expert or in the letter of reputation.
So your first point is there was no willful negligence.
That's right.
First thing.
And no case of willful negligence.
Yes, no willful negligence. And
That's it.
coming to this point. Second thing is that even if there was lapses was with the pump itself, which is not an insured item.
Right.
So these clauses of insurance, agreement of insurance, doesn't touch the pump. Touch the pump.
That's right. Now, may I just read the letter of reputation in some more detail? I have read the first 2 lines, that is what proceeds to make out the case for reputation. Then, please see, after they say it is rejected under exception O to the subject policy. Now, from the rationale of inferences of the forensic experts, Stream Fact Services Private Limited, which
Which you are reading out?
well, I was reading the letter of reputation in 739.
739, yes. Which paragraph?
Well, that's exhibit B. Now, I'm reading the paragraph after accordingly the survey has recorded. The next paragraph.
Now from rationale of inferences.
Inferences of the said forensic report, Stream Fact Services Private Limited, which dealt with the report and scientifically negated the finding of Perfect Forensic Science Society regarding a prior reason of loss, we further observe the following. I'm going to kindly try to fit this in 5A or exception. Safety operating procedure for fueling the tank of the crane was not being adhered to and safety precautions were not followed by the insurer. So, pertains to the tank. Then, the subject fire originated when burning high-speed diesel HSD got ejected with great force from the pump on explosion of casing of the pump and resulted in catching fire.
So your point is that pump is not an insured item. Pump is something extraneous. It caused damage.
Yes.
Explosion took place in the pump itself. So it's a pure case of accident.
That's right. Absolutely. I'm very grateful. But that is my case. But
pump is someone else's intruder. That exploded.
That's right. Now, even I shall show your lordship absolutely without any blemish of doubt that there was no negligence even in the operation of the pump. But be that is now confining myself to the contract. This is a claim arising out of the contract. The contract says that you can repudiate the claim only if 5A read with O is there. 5A is confined to the machinery. Not only to the machinery insured, but 5A is also confined to certain classes of act. And O says that there must be willful negligence, which must be an exception, which will allow an exception to the policy. Willful negligence. There is no allegation of any willful act.
This pump is under control of the supplier or dispenser.
That's right.
And it's their instrument which there was a damage or there was
that's right.
Explosion in that.
There is also no standard operating procedure which says A kind of pump or B kind of pump or pump or C kind of pump will have to be. Neither the manufacturer has stipulated nor there is any government regulation. Now, today I have to fall within 5A. I have to violate a government manifest in this regard, or I have to violate the manufacturer's manifest in this regard. That there is no allegation that I have done nothing. They say standard operating procedure has not been followed. But what is the standard operating procedure? There is no literature on that. What was the standard operating procedure? Either that was imposed by the manufacturer, that please follow this procedure during the refueling of the pump machine. Not mentioned. Government directives that this has to be the procedure followed. Not mentioned. But it is therefore only the exit to avoid the claim. Now, if your lordship sees whether I should read on. Safety operating procedure for fueling the tank of the crane was not being adhered to, and safety precautions were not followed by the insurer.
No, what is the safety operating SOPs?
We don't know. It has to be an SOP which is either statutorily mandated or mandated by the manufacturer, or otherwise available in the public domain with regard to refueling of mobile harbor. There is nothing. Then kindly see the next. The subject fire originated
when burning high-speed diesel got ejected with great force from the pump, on explosion of the casing of the pump had resulted in catching fire in the tires of the train. Completely bogus, but my lord, let us accept it for fact. Does not my lord satisfy either my lord 5A or O. On examination, it was found that the casing of the hydraulic pump exploded, making an irregular hole of about 10 centimeters in diameter, along with a propagated crack on the body of the pump. Does not fall within 5-year rule.
This is the explosion of some extraneous object, not subject matter of that.
No, that's it. Then,
And these cause damage to the insured item.
that's it. Now, the root cause of the fire incident was due to using the pump not adhering to the safety norm. Using the pump not adhering to the safety norm. What safety norm we do not know. And due to negligence in running the pump after closing the inlet valve, not willful negligence. Now, the difference in law is negligence. It is something that ultimately sounds in carelessness. Willful negligence, if it is the term of the contract, it sounds in something that must be a deliberate act. At least that is the law that your lordships have given.
A malafide must be there.
That's it. It must be willful. It must be deliberate. Otherwise, the expression would not have been used. Otherwise, simple negligence would have been there. The conscious use of the words willful act or willful negligence is what makes the entire difference. Now, not only have my learned friends not said that there is a willful act of willful negligence, but they have merely quoted clause 5 and exception O, but not said as well as what is the willfulness in that. They have merely reproduced the clause, that's all. And the reference is to the pump and not to the mobile harbor crane or to the crane itself. If this
That is cause is attributable to the pump.
That's right. Well, I say no, but I am for the time being proceeding on what they have stated. And I say even if this is taken as correct, which is not. Well, even then, it ultimately does not allow reputation of the claim. Well, particularly if you look at exception O, which is the basis of which the reputation has happened. Because that has to be a willful act, no allegation of willful act, or willful negligence. It has to be deliberate. And negligence with regard to the claim, but that is 5A read with. Now, so far as this is concerned, here, also kindly note that so far as the contract is concerned, I have not drafted the contract. These are all dotted lines, standard form contract. These are all contracts of adhesion. And if these are the expressions that are conscious leaves, then one cannot read the contract before this expression. Willful act, willful negligence.
SOP must be defined.
Yes. And not only that, what is the willful act? That must be said. What is the deliberate act? You must point it out. Deliberate act, with the greatest respect, must ultimately point at ourselves. That if deliberately caused the fire accident, with a malified intent that your lordship will just please to point. No malified is that. Now, so far as the law is concerned, apart from the fact that exclusion clauses in insurance contract must be very strictly and narrowly construed. That is the law. I take your lordship to the law later. The question is, if it is to be narrowly construed, can you say negligence and infer it is willful negligence? Can you say negligence and without indicating any willful act?
I accept your argument. Then even narrower or wider interpretation, whatever that means, that doesn't come here. That is not applicable.
I am grateful. That is my argument. And that is the first
Because
point.
your argument is basically that pump doesn't belong to or did not belong to the present petitioner or plaintiff. It belongs to and was controlled by someone else, third party. There was latches or there was negligence or there was explosion in the pump itself. That caused fire to the crane. Let me go with this different.
If I accept their case, as they made out in the reputation, it will be true. Which of course I have not accepted. I should show you lordship that this is.
Let us go with this. Then also it's a case of accident.
That's it. In that case, it does not ultimately fulfill the requirements of the exception clause O.
That is first point.
That's first point. The
second point is not accepting that.
Second point is, so far as the obligation, of course, this is not an exception clause. But my obligations under 5A are clearly demarcated. It is not including this. When your lordship looks at a clause say you shall do A, B, C. You shall do all acts pertaining to the machine, including this. Now, what the clause says is very clear. Clause 5 is said, insured shall take all reasonable steps to maintain the insured property in good, efficient working condition. There is no allegation there at all. So, this part is not even alleged. Then, ensure that no item is habitually or intentionally overlooked. No allegation of overlook. Then, insured shall fully observe the manufacturer's instructions for operating, inspection, no work. Manufacturer's instructions where it is flouted, nowhere mentioned. Then, insured shall also abide by government, statutory, municipal, and other binding regulations and force concerning operation, maintenance of the insured plant and machine. First of all, pump is not the insured plant and machine. Secondly, there is no allegation of any violation of any government, statutory, municipal regulation. So, 5 is not violated. 5 not violated. Allegation is not one of willful negligence. It says that you did not operate the pump properly. This was the violation. Accident clearly covered by the policy. Why should you refute this claim? Now, so far as this is concerned, now we'll kindly have a look at what is my reference case in the reversal. Because it is also very well established in law that a bond statement cannot be allowed to prove what he has not pleaded. Let us see whether he has pleaded any willful negligence. But kindly have a look at the written statement.
Yes.
May I show you lordship straight away paragraph 10. Before that it is not relevant. Or may I show from paragraph 9. This is what they say. During the subsistence of the said policy, apropos the defendant's Hostia Division Office, who issued the subject policy, received claim intimation on 27th April 2019 by plaintiff, reportedly for loss suffered due to fire in the said train on 27th April 2019 at berth number 13 of the Hostia port at about 8:58. Immediately on receipt of the plaintiff's intimation of loss, around 1:19 p.m., defendant, as per terms and conditions of the subject insurance policy, had immediately appointed a spot surveyor, named Shatrujit Khatua, to visit the location of fire and submit a spot survey report, and accordingly, the said spot surveyor submitted a report on the next following day of the incident, that is on 28th April. Now, I should show you, lordship, that there is no allegation of foul play here in this report. Thereafter, defendant deputed Otonu Paul, an independent surveyor, licensed by the insurance regulator being IRDA, to investigate, survey, and assess the loss as mandated under Section 64 UM of the Insurance Act 1938 as final surveyor on 3rd May 2019. That during the course of survey, plaintiff submitted claim form, and in the said claim form, defendant stated that the cause of loss as fire was caused by accident. Surveyor by his letter date 12 July 2019 stated that the source of fire is yet to be detected, and in his opinion, it would be advisable to appoint a competent forensic expert to arrive at cause of source of fire. Based upon surveyor's email dated 12 July 2019, now kindly consider this, when an accident took place on the 27th of April 2019. Now, the surveyor is seeking the appointment of a forensic expert only on 12th July 2019. Based upon surveyor's email dated 12 July 2019, Screen Fact Services Private Limited was deputed by the defendant to make a root cause analysis on the cause and circumstances of loss. Now, Screen Fact Services submitted their report bearing number such and such dated 9th August 2019, wherein the following observation was given.
Come from para A, sub-para A.
Yes, based on a thorough and in-depth inspection of the fire incident affecting mobile harbor crane at berth number 13, Hostia Port, belonging to such and such, that occurred on 27th April 2019 at 8:50 am, followed by search, examination, identification, collection, and analysis of physical and oral evidence, applying fire dynamics and information gathered during field visit was opined that the fire was B, not on account of spontaneous combustion, not on account of electrical related causes, not on account of arson. This is very important, not on account of arson. But due to closing of the inlet valve to the train tank, the temperature of high-speed diesel, enough referred to as HSD, in the impeller of the pump increased, igniting HSD, resulting in explosion of casing of the pump due to increase in pressure. The burning HSD was ejected with great force, which on reaching the bottom part of image train resulted in the tires catching fire. The root cause of the fire incident was due to using of pump not adhering to safety norms and due to negligence on the part of the concerned in running the pump after closing the valve. Now, may I just pause here for a moment? Well, my grandparents have said here, due to closing of the inlet valve of the drain pump, the temperature of diesel oil, well, in the impeller, well, what they say is, well, the valve is closed. So, well, the pump is running. The fuel is being generated. But well, because the valve is closed, the fuel is being pushed back. And that is well, coming back into the impeller of the pump, causing heat and well, causing explosion. Now, well, I shall show you lots of evidence that there is no inlet valve at all. So, well, if today there is no inlet valve, that can't be closed. If it can't be closed, there cannot be well, a reverse flow of fuel. But well, let us come to that chapter later. Well, I am now showing to your lordship what is well, their about cause well, for rejecting my claim.
Root cause of the fire. We'll submit. Don't be impatient. Root cause of the fire accident.
Yes. Root cause of the fire accident, well, it is well, due to well, the closing of the inlet valve to the drain tank. So,
No. Root cause of the fire accident
Yes.
was due to
due
using
to
of the
using
pump
of pump not adhering to safety norms.
and due to negligence on the part of the concerned.
Of the concern that is well, insured in running the pump after closing the valve. Now, so far as the pump is concerned, I shall also show you also that when today the tanker and moved away. On the tanker is moved away. How can the pump run? But let us confine ourselves to what they have stated. The root cause of the fire incident was due to using of the pump not adhering to the safety norms. Now, adhering to the safety norms, what are the safety norms? They are not specified. Well, running of the pump, not adhering to the safety norm. They have not.
And who is to adhere to the safety norms?
Well, naturally, the fuel agency or the fuel company. I cannot operate the pump because unless someone comes with the tanker and when the tanker is fitted to the pump, now the tanker will pump fuel to the tank. Well, only when the train is full or when the filling is complete, then it will be shut off. Well, coming back, the root cause of the fire incident was due to using of the pump, not adhering to safety norms. Well, safety norms have never been identified. Well, today there is no prescribed safety norm, either in the government notification or in the manufacturer's notification or even in the fuel companies.
Did you cross-examination on this?
Yes, plenty. I shall show you lots about that. But I am on a very fundamental premise. I am saying that if today you repudiate on the basis of exception O, you have to plead that this is a willful act. Where is that case made up? A willful act would imply a positive act. A willful negligence would.
Case must follow the four corners of this.
That's right. And these expressions are very conscious expressions and very consciously used in the contract. You can't then say negligence and willful negligence are the same thing. Otherwise, the word willful would never have been included. And now your lordship is aware that today, when interpreting a contract, you can't treat any part or portion of the contract as a useless surplusage. You can't treat any part of the contract as OTO or negated. Harmonious treating of the entire clause will have to be given. So when consciously the parties use the expression willful negligence, then you must give some meaning to the willfulness of the negligence. Well, even when common dictionary parlance, does your lordship understand by the expression will? Have deliberately done. Have willfully done.
It's a motive.
That's it. Now, I am just trying to show your lordship from the pleadings. Have they alleged this? Well, please read on. Well, thereafter, lordship has seen paragraph 10. Well, I shall not trouble your lordship with 11 and 12. Please come to 13. But my learned friend proceeded to say, I have not discharged the burden. Well, the burden is not for me to discharge. When you rely on an exception, it is for you to assert and prove. Number 30. To that the surveyor replied by email dated such and such, stating that he has submitted his final report, bearing number such and such, dated 11th December 2019, which covers all outstanding matters. Defendant once again sent an email dated 18th December raising specific query and confirmation of the admissibility of the loss of the defendant's liability. In reply to the said query, surveyor by his letter of clarification dated 21st December 2019 confirmed his recommendation for repudiation of the claim based on exception O of the said policy, which reads, as the company shall not be liable under this policy in respect of loss or damage, directly or indirectly caused by or arising out of aggravated by willful act or willful neglect of the insured or his reference. Now, this is what he says. One last paragraph, and I find no other reference to this. Please come to paragraph 70. Well, I shall not trouble your lordship with the first part of paragraph 70. Please come to the last 5 lines. Defendant states that the standard operating procedure was not maintained while fueling the tank of the crane, and the root cause of the fire incident was due to using of the pump, not adhering to safety norms, and also due to negligence on the part of the plaintiff in running the pump.
Your point is, nowhere this SOP was prescribed,
That's right.
not part of the contract,
No.
not a
part of the
statutory
contract.
SOP.
No. And not only that, but very important.
That's why this cannot be harped upon. This cannot be relied upon.
And it says due to negligence, not willful. There are cases, if at all, a case of negligence, not a case of willful negligence. Now, when you resort to exception O, then you must make out a case of willful negligence. If you have not pleaded that case, you can't prove it, and you have not proved. Because what they've said is, in fact, report, not pump not run according to standard operating procedure, caused the fire. I have two very important things which I shall come to later. They say that this occurred because the inlet valve of the machine was closed. Well, the inlet valve of the machine is not even there, so it can't be closed. Well, what will happen? Well, your lordship knows the standard feature of a car. Well, when your lordship is filling gasoline or petrol into a car, well, once the tank is full, well, there is a click sound. And well, naturally, you have to then extract the fuel because otherwise the fuel will spill over into the ground. Now, here, if there is a valve, that will close automatically. If the valve is closed automatically, there will be no further fuel going in. In that case, the
fuel was pushed back.
That's right. Now, the fuel will then be pushed back. But that can happen only if there is a valve. And B, if the tanker is still at the time pumping in the fuel. If the tanker is moved away, then there can't be any question of further fuel being pushed through the pipeline, pushed through the pump into the machine, and no question of retraction of the fuel. Now, be that I shall come to all these aspects because I shall show you lots of conclusions on the basis of documentary and oral evidence that A, there is no inlet valve at all which could be closed. B, if there is no inlet valve, there could be no question of pushing back the oil. And C, there cannot be any question of the pump impeller kept running when the tanker itself is moved. And there is no evidence found. Now, today, if this is the case, let me put it from another perspective. I have to then say that I kept the tanker running despite the machine being fully filled. Not their case. I have to say that I deliberately did so with the object of causing a fire accident. But there is finding that there is no arson. Then where is the case of
Admittedly, there was no arson.
So where is the case made of? Now these are the three
So
paragraphs.
according to you, it's rather a case of negligence. What they pleaded, case of negligence without being willful negligence.
That's it. And if they have not pleaded willful negligence, the law would prevent them from proving it. But in any case, they have not proved. What they have said in the written statement is what they have said in the repudiation letter and what Screenfax has said, which has been reproduced in the repudiation letter. So the question is, will this then permit my reference at all to come forward to defend the claim, will it not then amount to, my lord, a deliberate repudiation of, my lord, the claim?
Because according to Mr. Chaudhary, evidence led by you is a hearsay evidence.
Let us, yes,
So we have to go, suppose let us go with this version, because admitted fact did not be proved. So if we go with this version, then according to you, no case is made out by the defendant.
I am very, well, all hearsay evidence, not hearsay evidence, my lord, of no consequence, because, my lord, the law is
Admitted facts.
when today the insured has to repudiate a claim.
No, first part is admitted fact.
Admitted fact.
Second part, what is admitted is not properly applicable, comes within four corners of the agreement, warranting a repudiation.
Right.
That is your point.
Right. And my lord, if today, if your lordship is with me on this first point, we need not, my lord, travel through, my lord, all the evidence and all the other documents at all. Because, my lord, the repudiation then is, my lord, per se on the face of a crime.
Then you come and show the evidence.
Well, I should show the evidence on this manner, and then I should go to the other aspects of it. But, my lord, this is, my lord, the first point, and this is very fundamental because if your lordship, my lord, is with me on this, my lord, the case is decided on this itself. If the repudiation is not as per contract, then, my lord, the repudiation is wrongful. If the repudiation is wrongful, the claim has to be paid.
Yes.
Well, I can, my lord, proceed or, my lord, I can come back whenever your lordship.
Come back to on another thing.
Well,
Will you be able to come back?
kindly indicate, my lord, your lordship's convenience. Obvious. Well, your lordship will kindly indicate when it will be convenient for you. Come back whenever you lordship.
5th March is okay.
6th March. Well, could it be 6th March? Well, sorry, 2nd, 3rd, 4th, and 5th I have not kept.
Mr. Shah, would you have any problem if I take it in second half? Because first half I will not be able to take up these matters.
No, well, 2nd November, but kindly given on the 16th, I am not there itself.
Or 7th?
7th is also alright, 2nd.
Have you any problem? Or Mr. Shah, in part, adjourn to 7th March for argument.
Item number 10.
Witness is there. Come on the next stage. With you. How many days? How many adjournments?
2 weeks. I just need
How many adjournments you have taken?
by
Couple up, I can't remember.
two times I am sure. So my good boy, the witness was not in calendar, that's why I could not get it.
When you will be able to come?
Any day after 2 weeks.
On prayer of the learned counsel for the plaintiff. Witness action is adjourned to 26 March.
If my learned friend would be gracious enough in giving us an advance voucher, we can see.
Regular list. Item number 1. State Bank of India.
IDBI. Who is for the state bank?
Nobody is appearing.
Are there others?
Silently, my we have filed our written statement. It has been served.
But this should be a commercial case, commercial suit.
Probably, my lord, we will take it after 2 weeks. I will take instructions from my client.
Then appears for the plaintiff, state bank. Plaintiff. Adjourned to 26th March.
Item number 2.
But this matter is appearing at my instance and for the plaintiff. The interim order
For
which
the
was
applicant
but the interim order which was there was extended till yesterday. It was returnable yesterday, it did not appear, that's why we mentioned the matter. And we bring the interim order may be extended in the meantime and hearing of GA 4 and 7 can be fixed on a date.
Board had virtually become infructuous.
Yes.
Come on the next day.
The interim order may be extended,
But I am for the applicant in GA4, only two submissions.
Give me a date.
after 17th March, after the Holy Weekend.
Slightly longer, Millard, I will indicate GA4 is my application, I'm the
I
applicant.
will take up all these matters together. Come on the next day. After 17 months, you
After
say.
17th March.
On prayer of the learned council for the
Plaintiff.
plaintiff. So it is adjourned to 27th March for hearing interlocutory application.
With only one submission. Millard, GA4 is my application. I have misplaced. It's an admitted thing. I have written a letter to the plaintiff. Kindly let them serve a copy. But it is a humble request.
Before that,
Or else your lordship will
the interim order may be extended till the
Interim order is extended till the next date. Returnable date.
Only one thing, Millard, BPO to 26 instead of 27.
26th is very
I'm not difficult, sir.
26th.
let them serve a copy.
But GA4 is their application.
It is our application. I am admitting.
I'll give him a copy.
I'm so great.
Then application has become infructuous.
Whatever that might be, I have not passed any order.
I'm so great.
Big deal.
But take care whether this is a commercial matter or not.
No way. No. Very well, we'll undo all this.
Item number 3, item number 3, and for the plaintiff, have given affidavit direction in respect of the
GA4, what is GA4?
defendant's application for recalling of an order because it was now directed to an applicant. I have served my affidavit in opposition. I was a bit out of time. I need to find my
Recalling order of marking the suit as undefended.
Undefended.
may I find my affidavit in opposition.
If my lord can
23, 7, 24. Where is that order?
May I find my
2 weeks time for us to file replies.
When did you appear?
On the,
When did you appear in the suit?
on the 14th of January.
3rd of January 2000.
25.
When someone was, where is the report of the
When I've indicated in my affidavit when summons were served, I've also stated
September
that my was speaks to the direct affidavit.
December 2004?
24. I substitute and we appeared on the 3rd of December when we were given liberty to file.
Prosecution was only in respect of one defendant. The rest of the defendants summons were served long back. In fact,
And for
the
them,
advocate had entered appearance but did not file it.
that's the matter we are seeking recalling.
So you want to file WS?
Yes,
Is it ready?
yes.
Mother will not file it because it has been directed. If I have given an affidavit in opposition, let them give an affidavit in reply. Mother will tell me get out their application.
We are ready with all the witness statements of all the defendants. my lord. All we need
If
just a week.
opposition is filed by the learned counsel for the plaintiff, let the same be kept in record. Accommodation is sought for to file affidavit in reply. The same shall be filed on or before the returnable date. Then this would appear in the list. 27th March. Seven is Thursday. Thursday commercial and testamentary. Sorry. Right. 26.
Item number 4.
My application, she is my application to amendment of date. But I had received the letter from the defendant on November 29, 2024 that the registered office address of the defendant has changed. Even the
Any objection?
the address is not changed, my lord. I have indicated in the letter that the defendant had transferred its business to another company. Yes, that's the substituted form that company has also seen. Yes, that's
You make a substitution.
I have made an application for amendment because
Instead of amendment, you have to make a substitution because new entity is now the defendant.
in my
That cannot be done by way of amendment. Substitution cannot be done by way of amendment.
address may be allowed to be changed. Change the name. I'll make a formal application.
It's not change of name, it's substitution, application for substitution. With the change of registered address, new registered address.
New registered address.
I'm giving you liberty to file application for substitution, appropriate application, instead of amendment. GN3 of 25 is disposed of as withdrawn with the liberty to file appropriate application to address the issue. Accordingly, GN3 of 25 stands disposed of. This suit will appear in the list. How long will it take?
Within a week.
The suit will appear in the list after 4 weeks with liberty to mention.
Item number 5, this is my suit, it's a suit under order 37. Somebody sued for the last occasion, your lordship had interest.
What is GN3?
The GA3 is
A recent application.
the application for judgment on admission effective, summons of judgment. But you kindly see my application because they have not entered appearance, nor have they filed any application to defend the suit. The claim is against Millard, the company which is in liquidation, so we had served the official liquidator. Even in terms of the lordship's last order, we have been served.
Official liquidator must be made part then.
Well, the official liquidator is the part.
In this matter, the entire matter is also exceeded. So Lordship, my humble prayer with this application under Order 37 made for me to file a short affidavit indicating all the facts which are on record.
Liberty is given to file the defendant. File affidavit in opposition against GH3 of 24. The same shall be filed within 2 weeks. In the matter, affidavit in reply, if any, within 2 weeks thereafter. The matter will appear in the list on March 26.
Item 6 and 7. I appear for the respondents.
Where is Mr. Holt?
This they have filed it on the
Online.
they have filed, your lordship will recall, the issue is whether
One is whether these 3 or 4 Shebites should be discharged or removed. That is an application pending. Let that be addressed first. Which application is that?
well, there is a fundamental issue that needs to be considered.
No, first is removal is a very drastic step.
Yes, that is where I am addressing your lordship.
Which is that removal prayer? GA17 or 18? And 17 is for? 17 is your
GS17 filed by them.
GA17 really does not survive. It is really
Yes.
GA17 that has to be heard.
regarding Durga Puja in 23.
Yes, so that is over. My learned friends have filed a written note. Number, I had
For us, we are facing with this application of removal. What is the allegation?
there is no allegation. The allegation is that a committee has been formed in terms of your lordship's direction, modifying a decree, training a scheme in respect of performance of Pala. Now that committee has decided that I should not be permitted to continue as a Shevite any longer. The issue really is a question of law, and that is whether a vested right of Sheviteship which has come by way of a will can be abrogated by a group of Shevites acting in concert.
No, first question which is there. 3 persons who are about to be removed. Anulotta Dotto, Shukonna Dotto.
Well, I'll tell your lordship, pursuant to your lordship's order, a meeting was called for constitution of the committee. The agenda was only constitution of the committee. Net effect is we've all gone.
First thing,
May I just say this one before? They have given a note last week. I have considered that. I have to come back with a note.
Let me have my own clarification first. First thing is Shibai Thakur's to remove certain persons, K Yadav, Tobi Yadav, so and so.
And I am only concerned with 2 people.
Let me understand the whole resolution. Why you are about to remove them? What are their gates? What are their faults?
Well, they never perform their duties in the entire period after
All right.
forming
That is one
the
thing that I
committee.
understood.
We have decided to remove them for that, my lord, and we filed this, my lord. We filed this G18 for that purpose to absolutely whatever decision we have taken need to permission from your lordship. So that's why we have filed G18, my lord.
First thing
And
is
we also
removal.
formed the committee. First thing is we formed a committee, my lord.
Come before this court. This is not way how to argue. You can never try to understand. You are proposing to remove certain persons.
My lord.
What are their faults? They are not performing puja.
My lord.
They are not performing their pala.
Palas, also contributions.
Contributions. Can
My
it be said that they are working against the interest of the deity? Is it such a drastic step? How this
My lord,
drastic step is warranted? They
My
are
lord,
doing nothing against the opposite.
they are not only performing
They are indifferent.
puja palas, my lord,
I understand. They are
try
indifferent.
to disturb at the time of fire. My lord, we
That
have
their
filed
direction
criminal
should be
case
there.
against
They
them.
should
That's
not
why.
disturb. Direction should be there that they should not disturb.
My lord, kindly consider that if that whatever prejudice, we are not taking that decision for prejudice. My lord, this is decision that for further no Seva should do this type of activities at the time of
How can
Sheva
you
Puja.
remove them unless they are working against the interest of the deity, detrimental to the trust property, to the devotee?
My lord, as per will, they have to perform. They have to perform their duty. They never took initiation for that. That's why we have taken such decision, my lord.
What is no
So
argument?
this is the detrimental, my lord, and that's why we have taken. It's against deity, my
Where have you
lord.
stated in the notes of argument this point?
My lord, we have stated, my lord.
Where have you stated in the notes of argument? To come to this court, then I will hear. Heard in part, Mr. Ghosh is given liberty to file notes of argument. Adjourn to second April.
Grateful, my lord.
Formula dependent number 2. Miller takes for filings of the report by the commissioner.
What is the stage of the suit?
Because the partition commissioner has visited the premises and
Preliminary degree.
preliminary decree had already been passed by mutual consent of all the three parties.
Now this is for final degree.
Yes, my lords.
You are the partition commissioner.
No, Mr. Prova or Mr. Prova got chosen. Somebody Miller expired.
Is it ready or not?
No, Miller. We have been informed that somebody expired in his family. He is Miller unable to come Miller to he raised for Miller for that extension Miller for completion of his work Miller up to
An extension of time is sought for by the current partition commissioner to submit the report.
Miller requested your lordship to fix the matter Miller in the
But we are in February, it is sufficient this one. He has got so many days. I appreciate that he has got some bereavement in this family, but that does not mean he's only gone once from the day he has been
16th April.
Kindly makes this mandatory. I will inform
Current partition commissioner shall submit the report on that day positively.
I generally
What
don't
will
do
happen,
this.
Mr. Rai? If he is not able to do that, if something is there, then another partition commissioner is to be appointed.
Why I'm saying this, But initially, the partition commissioner, but in spite of court orders, he said that he is not governed by it. That's why he did not carry out the commission in the manner required. Then exceptions filed. Then your lordship decided on the exception. Their intervention application was disposed of. Then again, your lordship said, that just go and do this. We just have to enter, and that's about it. That is what I'm saying. It's not.
Honor, before that is before the next date. It must be filed.
I'm not objecting to him, but the time period is not required of so.
Otherwise, this
That's
court
why
may
I
not be very good or
One
congenial to the
house-
partition commissioner.
One house he has just got to
I
enter
understand
and
he has a bereavement in the family, but doesn't mean and the indefinite extension of time shall be allowed. I will be very harsh.
Like a 9, 10, and 11. Look, the defendants have not entered appearance in the suit. Initially, the suit was dismissed by the single judge. Honorable single judge taking up suits at that point of time because the writ of summons was not lodged. Thereafter, we
Have not been lodged.
Yes, thereafter we preferred an appeal.
Hmm.
For the division bench, upon payment of cost, the honorable division bench was pleased to restore the suit and directed the defendants to file the written statement within 6 months. 6 weeks, I'm so sorry.
Writ of summons or written statement?
Written statement. Restored the suit upon the
Where the defendant?
Whole India. Well, they never entered a This is an order of 2018, not 2019. But
Unless summons or writ of summons are served upon them, how they can appear?
no, we have it's recorded in the order of the division. We ordered division bench order. 888.
No, division. There is no order of dispensing.
Well, this is the direction.
Direction to file writ of summons. Have you filed that?
Written statement, my lord. Lordship, is the second page, the last paragraph. The respondent will have 6 weeks from the date of receipt of a copy of this order to file its written statement.
None appears for the defendant. The division bench in terms of order dated 18th August 2019 noted that the defendant appeared in the suit. The respondent in the appeal was aware of the suit and directed to file written statement within 6 weeks from the date of receipt of the copy of the order. The order was passed on the 8th August 2019 and till today no written statement is filed. Let the suit be marked as non-defendant. Fixed for hearing of the suit on fixed. It should be a commercial because they are commercial premises used for commercial purpose.
Yes. It takes extra efforts.
10th March.
Very
The suit shall be all the
All
three suits shall be transferred to commercial division in the meantime. and the defendant and the plaintiff shall take necessary steps in compliance with the Commercial Courts Act 2015. Full stop. The department is directed to do the needful.
What should call for a report?
The report of the registrar will be kept in the account.
Great. For 12 and 13, I can do 12 and 13. For the payment number 6, what has happened with it? Subsequent to filing of this application, the probate was granted in 2023 of premises, sub premises. By this where the defendant, the plaintiff number 5 and 6 now are the only sole the owners of this property. So its consequential amendments would be obtained. And deletion of the name.
Where is the application?
193 for the GA1.
GA7 of 27.
Yes.
Who is the defendant now?
Defendants would stay.
Defendants are there.
Yes.
Where for the defendant?
No, he's for my advocate on record. What has happened, Milord? Taradeli Agarwal was originally the owner of the
Have
entire.
you served the copy?
Milord, it's taken on to the master summons, so it had to be served before. Had to be signed by.
None appears for the defendant.
No, in the last occasion, Lordship had also directed that none appeared, but still, Milord, Lordship had directed that. So
No affidavit in opposition is filed. Is it there?
we have not received.
That is that. It's no opposite affidavit in opposition is there. It's it should be for testamentary matter.
Yes, but the
No, see,
this amendment has to be allowed, then thereafter we can come back. The application for amendment has to be allowed. But after the probate.
24th March for hearing of the application.
Should I nevertheless serve the respondents once?
We can do it. We can do it.
And 30 similar matters.
Both the suits will appear in the list on the same date.
Item 14.
My lord, in item number 14, my lord, I am hearing on behalf of the plaintiff, my lord. My lord, in this matter, there is a direction to prepare the justice documents, my lord. It's being prepared, my lord.
File.
Kindly
Extension of time is prayed for to file judge's brief of document by the learned counsel for the plaintiff. Prayer is allowed. It's 24th March. For filing judge's brief of document.
great, very much.
Yes.
Nine, 10, 11.
Before your lordship takes up the 2 p.m. matter, item numbers 8, 9, 10, and 11. Lordship has directed it to be transferred to the commercial division. Now, my lord, this is a case where, my lord, we had
9, 10, and 11.
Yes, my lord. Of
The
the
non-commercial.
106 issue, my lord. 106 is now, my lord, before there are different views, my lord. The prevailing judgment says in case it's a eviction based on a 106 notice, my lord, it will not be a commercial dispute.
And he's also passed us in
Lordship has also
Division bench order is there.
my lord, division bench, there's a referral and single benches.
Lordship
Deepak
sorry.
Polymers is here.
What is your prayer?
My lord, your lordship has directed the matter to be transferred to commercial division
What is your prayer in this suit?
for eviction and mean profit.
Yes. Recovery of money.
Yes, my lord.
Out of movable property. That's why the proviso will come.
But, my lord, because there's no agreement, lordship will kindly see 106, my lord, proceeds on the basis in the absence of a contract to the contrary. Now, my lord, going by that provision, my lord, I am, in terms of Deepak Polymers, my cause of action arises out of failure to comply with the notice under section 106, and it is not a dispute considered to be a commercial dispute under the commercial codes.
At a কাজ করো, come
OD, my lord, the regular list.
And he's also passed us in
9, 10, and 11. I should have indicated this when your lordship took up the matter. It was mine.
come on Friday.
I'll come back on Friday.
No order today. Come on Friday.
Grateful.
Grateful.
I have to see your 106 notice also.
May I have my lord's kind indulgence to mention one company matter? This matter was previously mentioned on 19th February, where lordship was pleased to direct the matter to be listed as to be mentioned. The matter has not come up yet, my lord. This is a
Come up in the
order.
list. It will come up in the list in course of time.
Lordship, the difficulty is we have a time bar between 3rd April to complete the e-auction, and the order requires a small correction. It's a matter of 2 minutes, my lord. Let it be listed. Much obliged.
আজকে হবে না অন্য একদিন দিয়ে দাও
Commercial division, item number 7.
Yes, my lord. Well, this is regarding the employment agreement of 2nd
Yes,
of
your
August.
defendant.
I am for the plaintiff. Defendant has a counterclaim. My claim is on account of the return of advance money that was given to the defendant. Lordship will see, but as I had indicated, there are principally 3 issues. The first issue is, my lord, whether the defendant's appointment in the plaintiff was valid or not. This is number 1. Number 2 is whether it is invalid because the other technical experts from the rubber chemical field
joined or not.
Yes, whether they joined or not. It was the assertion of the defendant's witness that they joined. But in cross-examination, when it was put to him that produce a document in that regard, he is completely silent and he had avoided the questions. In fact, it was our assertion in an email and in a letter of 2019, September and November, that the other 4 experts from the rubber chemical field did not join. In his cross-examination, my lord, he has admitted that I have nothing to show that I have disputed the assertion made in those letters. Now, in this backdrop, if the appointment or the appointment as a consultant, if it did not take effect, then, my lord, the advance given to him on 3rd of August 2019 is required to be returned.
Where are the exhibits?
Yes, my lord, if lordship sees, my lord, the first exhibit is, my lord, exhibit A, which is at page, exhibits are separately, but if lordship takes the judge's brief of documents.
No, I want to see the exhibit number. There's a draft agreement.
Yes, exhibit A is the email and exhibit B is the draft agreement.
Yes.
Now, my lord, if lordship sees exhibit B, my lord, paragraph 1, my lord, I'll just place paragraph 1. Your appointment with ML is Markham Limited, my lord, the previous name of the plaintiff, as a business consultant will commence on your joining ML immediately after joining of such individuals in ML as mentioned.
So it's a contingent appointment. According to you, it's a contingent appointment.
Yes.
his employment or his induction will only be valid after the other experts join simultaneously with the plaintiff.
So this is the core issue.
This
Whether
is
they have joined or not.
whether they have joined or not.
Since they did not join,
The employment agreement or the agreement of 2nd of August 2019 did not take effect.
so
Agreement was there.
he must return the benefit taken by him.
Yes, that is the long and short of the matter. Because Lordship sees Malad exhibit Malad G onwards. Exhibit G, Malad Lordship will find separately, it is also there, Malad, in the judge's brief of documents also. Malad, page 36, if Lordship sees of the judge's brief of documents, Malad, we have page 36 is exhibit G. Malad, this is
জিটা কোথায় লেখা আছে এখানে?
I think it was marked separately.
Some are here, some are there. Everything is most unruly way evidence was adduced. There's no discipline in anything. Exhibit D is the letter.
No, I am on exhibit G.
Yes.
Yes.
Invoice and debit note.
Yes. If Lordship kindly takes the next page, if Lordship is looking at page 37 of the judge's brief of documents or separately the exhibits, but kindly see, this is the invoice that was given by the defendant. The first document is dated 3rd of August 2019, and Lordship will see from the description, advance against my proposed appointment as a business consultant and services to be provided to Markham Limited pursuant to engagement letter dated 2nd of August 2019. So the defendant admits that advance was given to him for his proposed appointment as a business consultant and services. Well, this is very important, to be provided to Markham Limited. So it is the defendant's assertion that the appointment was number one proposed and services that were required to be provided. So he has not rendered any service. Advance payment was given to him for his proposed appointment, that he will be appointed, and services to be rendered later on. This is subject to, my lord, in my humble submission, in terms of the agreement, the appointment will fructify or he will be entitled, my lord, to render service provided his appointment is considered to be valid. Now his appointment will only be considered as valid if, my lord, the other experts join simultaneously on the date of appointment of the defendant. That is, my lord, clause 1 of the agreement of 2nd of August 2019. But similar documents, now if Lordship will see,
the next one is also to be proposed.
Yes, everything is to be proposed and for services to be rendered. Lordship will see, my lord, an identical document is also there at page 39 of the judge's brief of documents.
Do one thing.
Yes.
You make a compilation of all the documents exhibited.
Very well, my lord.
Because I have to switch over from here to there to here. That's very difficult.
I'll prepare a
some in judge's brief, some in plain, some in the file.
I'll prepare a compilation
with the exhibit numbers.
Very well, my lord.
You have exhibit A to B, C, D, E, F, so and so.
Yes. My lord, in the
make a compilation.
Yes.
And make the exhibit mark on the each document.
Yes, I'll prepare a compilation and I'll
in part
prepare an index.
with indexing.
Yes.
আমরা দিয়ে দিয়েছি।
Argument to বুঝিয়ে আছে। Comes. 13th March.
13th March. Great.
No, 13 must. There's that 13th, 14th. Just
18th March.
yes.
18th March.
18th
Great.
March কটা matter আছে?
18 March. 13 March.
18th March.
18 March.
Great.
But we have submitted our written notes to the court. I have done it.
Argument হবে. Maybe argument.
Item number 9.
In this matter, Mr. Shatodip Bhattacharya is appearing for the appellant, Lordship. Kindly make it not today. He is engaged in court number 16, Lordship.
দেখি একটু আর্গুমেন্টে কত অবধি হয়েছে possibly last time I also adjourned the matter.
Yes. Or make it after third passover, Lordship.
I'm keeping it passover.
Yes, Lord.
You are the defendant.
I'm the defendant, my lord. My counterclaim.
Counterclaim is there. I will hear it today. Whether it will come, whether it will come or not, I will close argument. I'm telling you.
It's coming, Lord.
Regular list. Item number 15 and 16.
There's a stage of argument.
Yes, my lord. My lord, with my learned seniors leave, my lord, may I, my lord, proceed, my lord.
Who is your other side?
Mr. Rupak Ghosh, my lord.
Mr. Rupagosh.
My lord, may I, my lord, proceed, my lord. On the last day, my lord, when we commenced our argument, Lordship has rightly said that you prepared a compilation of the documents. Otherwise, it would be very difficult for your Lordship to switch over from one document to another. So, in that regard, we had prepared a compilation. I would proceed my argument on the basis of that compilation itself, so that Lordship doesn't have to look into any other document.
Yes. Exhibit marks are written there?
All I have given. Now, my lord, I have done it, my lord, in 5 different parts. One contains the orders. The other one contains the compilation of exhibits on the preliminary issue. That is what the court has to be decided, my lord. Then, my lord, the important list of important documents, meaning thereby the documents which have been exhibited. And I have paginated those also. So what I would request, well, I will be arguing just to look into those documents and no other documents at all. So may I file the compilation before your lordship? And one more compilation I have prepared, that is related to the law. I'm not handing over right now because first I would be
Let the argument be over.
Yes. So 4 compilations I'm handing over right now.
What is CS 576?
576. এটা দিচ্ছি না এখন কেন এটা আইনের ব্যাপার ওটা আর্গুমেন্ট হয়ে গেল
Let me understand the fact first.
Yes, I tell your lordship. The suit is filed by the defendant. Defendant says that I have an agreement with a lady called Mrs. Helen Wilson.
You means?
Helen Wilson.
You means?
I am a plaintiff. I am the defendant right now. I stepped into the shoes of the lady. Plaintiff means.
What is your name?
My name is Dr. Narendra Kohli.
Kohli, yes.
Yes.
Dr. Kohli.
Now, the lady had passed away. I stepped into the shoes. How I stepped into the shoes, that is by virtue of a will. And that matter, Lordship is hearing, that is the testamentary suit, where at presently, my lord, I am cross-examining Mr. Ghosh's witness, Mr. Balbhadra Marothia, who is the son of Ratan Marothia. Now, Ratan Marothia had an agreement which was dated 2nd January 1989 with Mrs. Wilson. So whatever is said in the plain and written statement, that may not be required to be placed at this stage, because we filed an application in the suit under Order 7, Rules 11, saying that it's barred by law. Now, why we took this point? We said,
no, let me understand. This is a suit by
Ratan Marothia.
Ratan Marothia against
against
Mr.
Mrs. Helen Wilson initially.
Now, Mr. Kohli.
Mr. Kohli is also a party.
Praying for
decree for specific performance of an agreement.
And so far as CS 11 is concerned?
CS 11 is a suit where a decree has been sought for seeking cancellation of the will. EOPL.
By the same person.
By the same person. Now, how far that suit is maintainable, that will be decided at the time of hearing, because normally the cancellation of a will normally doesn't happen. Either will is there, genuine, probated or not granted.
Testamentary court will decide.
Absolutely, my lord. Today we are concerned with this limited issue, whether the suit is barred by law or not. Because when we filed that application under Order 7, Rule 11, we said it's barred under Section 31 of the Foreign Exchange Regulation Act 1973. Why? Because at the time of entering into the agreement, a permission was mandatorily required to be obtained from the RBI for executing a conveyance or for selling of a property. And admittedly, that has not been done. So if that has not been done, then obviously decree for specific performance of that agreement in respect of which enforcement has been sought for by seeking a decree cannot be passed. That is clearly barred by law. Now that application, my lord, was dismissed. So we went up in appeal. The appellate court modified it and passed an order saying it's a suit of 30 years old. Therefore, certain points are required to be gone into. Evidence is also required to be gone into.
That will be decided as preliminary.
By the trial court. And whether that's a question of law or question of fact, that issue also needs to be gone into. But the issue what needs to be decided is whether the suit is barred by law. If it is decided as barred, there is no point continuing with the litigation, because that will be an harassment to a litigant, to the defendant. So you decide that issue first. So apropos to that order, my lord, we, my lord, went before the trial court. Justice Shamanto was sitting then. He was in scene of the matter. So we proceeded and we showed the order. And Justice Shamanto, my lord, had passed an order making an additional issue. On that, according to his lordship, that certain documents are required to be produced and exhibited to prove that case. Now, what is that issue? Issue is whether the suit is barred by law, by virtue of Section 31 of the Foreign Exchange Regulation. Now, that order had also been challenged subsequently by the plaintiff, went before the appeal court. The appeal court just modified the order, because while passing that order, Justice Shamanto observed that these documents can be treated as an exhibited documents. Division bench said, no, that cannot be done. You have to prove those documents by calling the witness to the box. 7 except that, the entire order passed by Justice Shamanto remained intact. So now today we are before your lordship. Witness was examined. Dr. Kohli was in the box. He has deposed. He was cross-examined. Mr. Marotia's son, Balbhadra Marotia, was in the box. He was cross-examined only on the limited issue whether the suit is barred by law, or in other way, whether it's barred by virtue of Section 31 of the Foreign Exchange Regulation Act. That is what the court has to be decided. I have prepared my compilation based on that. Now, my lord, may I, my lord, just show your lordship? The very short point. May I, my lord, just show your lordship to the compilation which contains the orders. Copies of the orders to be relied upon at the time of final hearing. Lordship will find that there are 4 bunches, 4 compilations I have given separately. Lordship can take that one. Just one order I will show. Serial number 6, Lordship has got it, my lord. Page number 2. Order passed by... Serial number 5, Lordship would kindly comes to order passed by Honorable Justice Robindranath Shaman. Lordship has got that.
Page 15.
Yes, page 15. Order starts. I would request your lordship to come to page 19 straightway. আমরা compilation 4 নম্বর order এটা আমরা 4টে compilation দিয়েছি 3টে কোনটা দেয়নি ওইটাই দেয়নি order এর compilation একটা ওনাদের Kindly come to page 19, straightway.
19.
Yes. Because only the observation and the finding I will show. I will not trouble your lordship to go into the other things. That is not required at all. My lord, it's second paragraph. In view, lordship has got it, my lord. Third paragraph, precisely.
In view of
yes.
the above and in
yes.
exercise.
Yes. The following additional issue being additional issue number 5 is framed. Is the suit barred by section 31 of the Foreign Exchange Regulation Act 1973? So this is what the court has to decide at this stage. This is my submission. And obviously, there is no other way because this issue needs to be decided at this stage. Now kindly turns over to page 20. Why the matter went up to the appeal court and what the appeal court has modified, I also have to point out.
Maybe admitted.
Yes. Now kindly comes to the
Anyway, these are not relevant because
not
appellate
relevant,
court have
not
said the
relevant,
things right.
not relevant at all. Now, my lord, kindly takes up the bunch which contains, my lord, the plain and written statement. I would first, my lord, show your lordship.
First, I want to see the order of the division bench.
Division bench. I was about to show you that, my lord. Very well. Kindly come to the order of the division bench where this issue has been decided that this needs to.
Yes, preliminary point.
Very well, very well. But first document, serial number 1, page 1 to 5. Internal page 4, if lordship sees. May I, my lord? The suit is more than 30 years old. It is awaiting trial. The above issue is of paramount importance. It goes to the root of the matter. Lordship has got it, my lord. If the defendant number 3, the appellant is able to show, defendant number 3 is Dr. Kohli, is able to show that for lack of permission by the Reserve Bank of India to sell the immovable property, even an agreement for sale could not have been entered into, then that is the end of the matter. The agreement would be adjudged as illegal and void. No suit could be based on that agreement. Hence, the suit could be adjudged to be barred by law. This point going to the root of the matter has to be adjudged first before the other issues are gone into by the court. From the record, it is not clear at what stage the suit has progressed, but it is clear before the suit is to progress and further, then this issue has to be determined as a
It was left to the trial court.
Absolutely, absolutely.
Now, thereafter, what happened?
Justice Shamanto's order, framing the additional issue, page 19.
Page 19?
Yes.
Is it preliminary issue?
Yes, that's an additional issue.
Additional, but not preliminary.
But lordship would take it because that is the only issue. That's an admitted position also.
So far as other issues are concerned?
Not required at this stage, after the observation of the appeal court. Kindly see the next paragraph of the appeal court. That would make the position probably more clear. Now, to determine this preliminary issue, issues of facts may have to be determined by the court. According to us, it should be left to the learned trial judge to come to
with a mixed question of law.
Absolutely, absolutely. And the court decided it's a mixed question of law and fact. Evidence is required. That I have shown from Justice Shamanto's order. Now, kindly comes to another order, Justice Tandon's order. Just for a moment. Page 32.
22.
Sorry, page 22. I'm very mistake. Page 22. I'm not placing this, Millard. Kindly comes to the operative portion. Page 30. First paragraph. We do not intend to make any comment on page 30, internal page 9 of the order. Lordship has got that, Millard? Yes. We do not intend to make any comments on the coordinate bench decision. That is the first order of Justice Mukherjee, which I have shown to you right now, page 1 to 5, which has attained finality at this stage, whether such issue is a mixed question of law and fact or a pure question of law. And respecting the dictum of the said observations, the harmonious interpretation which can be given to the said judgment.
Preliminary issues to be decided.
Absolutely. Now the next. However, we do not accept the portion of the order. This has not been troubled with. What has been troubled with or modified, this is this part. However, we do not accept the portion of the order where. Sorry, Millard.
However, we do not, yes.
Yes. However, we do not accept the portion of the order where the single bench has admitted such documents disclosed in the written notes on argument to be admitted in evidence. And
How
there,
this can be?
yes, so that's why the witness has been called. Absolutely right. We accepted the order. They went to a Supreme Court dismiss, so the order stands. In view of such, my lord, when this matter commenced again, witness was in the box and he proved the documents. He was cross-examined by Mr. Ghosh. His witness was there, cross-examined by me. So now what the court has to see? Whether, my lord, the suit is barred by or not, after considering the documents which have been exhibited, and of course, after considering the pleading made in the plaint. That is what the court has to decide. Now, my lord, kindly comes to the document which contains the plaint and the written statement.
Important documents.
Important documents.
Volume 1.
I will show you, my lord, which volume it is actually. There are 3 volumes I have handed over to you, lord.
Amended plaint.
Yes. It's in volume 1, amended plaint and the amended written statement. Just a portion I will indicate. Page 20 to 48.
Page
20, the amended plaint starts. I will not trouble your lordship to go into that. What I would request your lordship.
No, page 20 is not that.
Page 20 is not there. But lordship is probably looking at the different volume alert.
Volume 1, list
volume,
of important documents.
Yes, volume 1, list of important documents. First document is letter dated 14 December 1980.
Amended plaint 20 to 48.
Yes, yes, my lord. Yes. Page 20 kindly comes to, my lord, page
20C 20. Application for permission of Foreign Exchange Regulation Act.
Page 29, lordship kindly comes to, my lord. My advocate on record. I'm sorry, my lord. It tells me there is a mistake, my lord. Kindly comes to, my lord. Page 29. I would find it out for your lordship, my lord. Kindly gives me. I will correct it afterwards, my lord. I will find it out. I'm extremely sorry, my lord. It should have been done in a proper manner, my lord. Lordship has got that.
Yes, at all material time, Mr.
Yes.
Salenu himself.
Kindly do not go into that. Factual aspect relating to other issues. Only the relevant issue is whether it's barred by or not. Straight away, kindly comes to the prayer. Internal page 10. Internal page 10, my lord. What they have claimed.
Decree for specific performance.
Absolutely. Decree for specific performance of the agreement for sale dated 2nd January 1918 of the premises number
Execution and registration of documents.
Yes.
Also.
In default.
In default by
conveyance. So basically, other prayers have also been made. That is damages, injunction, not concerned. What we are concerned is also E. E, next page. In the event specific performance of the not granted, then they say
decree of 6,35,000.
Money has to be refunded. Now, what is our contention, my lord? The contention is that decree cannot be passed because the agreement itself is a void one. And I will cite the authorities on this. That is sum and substance of my point.
So if you succeed in your point, you have to only say that FERA is violated, Section 30 of FERA is violated.
The agreement has been entered into.
And possibly this is not a disputed question of fact.
No, undisputed question. Undisputed, I'll show you from the evidence that when the agreement was entered into, there was no permission at all. The defendant, through their advocate, wrote a letter asking Mrs. Wilson to seek permission from the RBI. So that is because that permission was not entered, permission was not obtained, and that happened after entering into the agreement. There is no dispute to the fact that the lady is a British national. Passport has been exhibited, proved. So admitted position at the time when the agreement for sale was entered into, firstly, she was a British national. Secondly, she did not have any permission from the Reserve Bank of India. So at that juncture, when admitted position is such, where the decree in the nature of specific performance of that agreement can be granted or not. My answer, my respectful submission is no, because it's a bar under 31. That's the point. Now, kindly turns to the written statement. I have to show whether this point was taken or not. After preliminary issue, it may not be required, but even then.
Page
My lord, kindly comes to my lord, page 49. Lordship has got that, my lord. Page may not tally because the plane did not tally page number. It may not. Kindly comes to paragraph 14C.
So Carapiet was also here in this flat.
Yes.
That Carapiet's case.
Carapiet's case. Suggestion. May not be the same Carapiet. At least we did not suggest anything to that effect. Now, my lord, kindly comes to page 63, internal page 15.
Internal page?
63. Running page 63, internal page 15 of the written statement.
14C.
Absolutely. This point was specifically taken. The defendant is a foreign citizen, and under the Foreign Exchange Regulation Act 1973, the defendant cannot sell or transfer the said immovable property without the prior permission of the RBI. There is no term in the said agreement for sale stating that the defendant shall obtain requisite provision of RBI. So the lady took the stand. There was no provision. More so, the admitted position is no permission had been obtained.
Yes.
Now, Lordship sees the documents. Kindly take the volume where, my lord, the documents which have been exhibited, compilation has been made.
Let me see the agreement first.
Yes, absolutely, my lord. I will take your lordship to that. My lord, compilation of exhibits for preliminary issue, serial number 4. That is the agreement. It's not in the same bunch where the plain and written statement, my lord, these documents have been annexed in the other bench. Compilation of exhibits for preliminary issues. If lordship takes that bunch, fourth document is the agreement for sale dated 2nd January 1989. Page 10 to 11. My lord has got.
These I can't read.
Lordship can't. It's illegible, absolutely.
See it?
Lord, there is. এটা জজ সাহেবকে দেওয়া হয়েছে, এই কপিটা সত্যি কিছু পড়া যাচ্ছে না, তো কোনটা পড়া যাবে একটু বলুন, সেটা তুলে দেবো। এটা সত্যি পড়া যাচ্ছে। Lord, there is one more compilation of exhibits for preliminary issue.
Let me see the exhibit itself.
Yes.
Exhibit gulo.
This is, my lord, exhibit. I have given the exhibit number also. This is exhibit 3. দেখে করতে হয় একটু। Exhibit 3. I'm extremely sorry for troubling you, my lord. Exhibit 3. এটা দেখ। আরগুলো পড়ে জাস্ট এক্সিবিট 3 তে একবার জজ সাহেবকে দিন।
এটা এখানে দিয়ে রাখো পাসপোর্টটাকে। This agreement for sale made in 2nd day of
2nd
January.
January 1989. Buy-in between Mrs. Wilson.
Itself is thinned out.
Lordship, this is legible probably.
Better.
Yes, better, yes. That's the correct term, my lord. Well, total consideration money is 30 lakhs. And I think 3 lakhs or 1 lakh had been paid. And the agreement, as on the date, stood cancelled because Mrs. Wilson had cancelled. But that's a different thing altogether. Kindly see the name of the parties with whom the agreement
Ratan Marothia?
Yes, was entered into. Presently, Ratan Marothia had passed away. So his son was in the box.
And Mrs. Helen Wilson.
Mrs. Helen Wilson.
About to be obliterated.
And kindly, my lord, comes to the last page where the parties have signed. I put few questions to the witness. Generally, my lord, lordship
Just a
would
minute, let me go through this agreement.
absolutely, my lord, I would wait. Clause 3, lordship would find 1 lakh was paid as an earnest money out of 30 lakhs, which was the total considered money as reflected in the agreement.
Now, Mr. Dev, one thing.
My lord.
Agreement for sale was made.
Lordship.
Suppose this is infringed FERA, section 31 of FERA.
Lordship.
Now, FERA says permission is to be taken
Lordship.
by a foreigner for purchase of a property.
Lordship.
It is not done.
Lordship.
Sale cannot materialize.
Absolutely.
Is that a bar for filing a civil suit?
My lord, when you
Is there any bar?
My lord.
Two things are different.
Lordship.
One is remedy is barred. Remedy or right, whatever that you may say, because you may not have a right to enforce this agreement since necessary permission under FERA was not taken.
Lordship.
But this should not be an impediment for filing the suit.
Never ever, I tell you, Lordship. Even a time-barred claim can be filed. It's a person's discretion.
Yes.
Who has come to court. He's trying his luck. He's paying the court fees. At any point of time, a litigant come and approach
because
the court.
bar of the suit and bar of the remedy two are different things.
That's right. I say that the relief claimed in the suit cannot be granted. That's why I say it barred by law.
For the timing, let us accept it. Accept this proposition. Relief cannot be granted.
Why? Because this agreement itself is not enforceable in law.
That will be decided in the suit. For that suit is to be proceeded. There is no bar in filing a suit.
I'm not saying for a moment. Nobody can say you cannot file a suit, as I given you.
Because whether this should be decided as preliminary issue, that is, suit is barred by law.
Absolutely.
Whether
in view of the bar as contemplated in section 31.
31. So, whether the suit is actually barred, remedy may be barred. What section 31 contemplates, a remedy may be barred. He may not get remedy, may be out of suit.
I tell you, Lordship, giving an example. I file a suit and I seek certain reliefs after paying the court fees. If the relief cannot be granted on the face of it, here in this case, after taking consideration of the evidence, because the court has said it's a mixed question of law and fact, what remains in the suit?
Because what will I consider right now is whether this section bar filing of the civil suit.
No, not necessarily. There I join issue, my lord, with greatest of respect. There I join issue slightly, my lord.
That when relief is barred, suit is also barred.
Absolutely. Like I tell you, Lordship.
Now come with your notes of argument.
I would. Just giving you an example before I stop. I file a suit, my lord. Knowingly or unknowingly, it's barred by limitation. It happens. So nobody can say you cannot file a suit.
The case may be defeated.
Filing of a suit, it's a original proceeding, no doubt. Section 5 of Limitation Act does not come into any effect, any application. If it is found after filing of the suit, an application is taken out under Order 7, Rule 11 as barred by law, by taking the plea, on the face of it, it appears ex facie barred by limitation. Will the court proceed with the suit? Court will dismiss the suit. Why? Because it's not maintainable.
You come with the notes of
I would
argument
come.
next.
I would come. I would come.
Don't rely on this document because these original document, those copies are itself illegible. How can I get a copy from me?
No, I hope, my lord, because these documents have already been.
The point is crystallized. You come with your notes of argument, that only I look.
I would come, but before that, give me 15 minutes time to place the documents. Though again, I say documents are admitted. What I have to convince and satisfy the court that if the agreement is otherwise found.
Your point, you have to demonstrate or you have to explain this point. If the agreement is barred, does it imply or consequence is that the suit itself is barred? Bar of suit is bar of jurisdiction. Suit is barred to exercise jurisdiction.
Yes, but I put it in a slightly different way. As I given you an example for limitation. Suit instituted. As on that day, if the court finds that the relief sought for in the suit is not maintainable as on the date of institution of the suit, will the court allow the suit to be progressed for further hearing, or will the court dismiss the suit? That's the point.
All right. Come with
I would
that.
come back.
Hard in part adjourned to Lombard
Any day, my lord, at the earliest, any day convenient to the court.
I think you go with them. Or do
13th I am here. In March.
Can accommodate little.
30th we won't come.
No, we'll all be coming.
30th we won't come.
No, 30th we will be
My lord,
coming. We won't be coming in April 15, 16. High chance.
13th March.
13th March, madam.
Aage date nahi?
My learned senior is saying for an early date. I leave it to your lordship.
No, I also don't join issue there. একটু আগে দিয়ে দাও না মাথায় ফ্রেশ থাকবে জজ
10th is okay? 10th March.
Absolutely.
Because Mr. Dev, one thing,
lordship,
suppose this agreement cannot be specifically enforced. In that case, some alternative remedy may be given.
Compensation. Who is
Alert.
to grant that?
You come with this notes of argument.
I would come back. Compensation based on what?
Whatever that
I would come back. I would come back. Today I will
It's
not.
not compensation. If on the strength of this agreement, suppose the agreement is void, you have retained or get some advantage, that is to be returned.
The money that
Under
I paid.
67.
I will come back. I will come back. I will come back to this. Did you go back?
No. On that day.
On that. We will come back on this. Wait.
Okay.
Commercial division, Procedural matter, item number 9.
So Mithro is here. He is saying you didn't do justice to your name. I said, why? He said, Chichi. I do not know.
My lord, I told him that this is not what we learned, that when you have a senior, the senior should address.
Which one?
This matter, the earlier.
But I am blessed with a senior like Mr. Sharkar,
who
guides me,
who
guides me and allows me to argue a case,
তোমার মতন
sitting by
junior
my
থাকলে
side,
কি করবে?
and that he teaches me.
Well, it's between us, man.
Always, that is what we have, my lord.
All right. 9.
Item number 9. Mihijam Banaspati.
What is your matter? Sir, what is your matter?
17. No, of course.
Oh, Tiberwal. Yes, let me hear.
Mr. Mitro's matter.
Yes, you come. That is because you are senior.
I have one difficulty on the last day, my lord. I was held up in some other court. Now today my difficulty is Mr. Ghosh is not there. But I can, my lord, try to assist your lordship.
Yes.
My lord, lordship is aware, my lord, suit for specific performance. My lord, I had on the last
Coercion, possibly. Coercion.
I shall come to that. I shall come to that. On the last occasion, my lord, I had placed the plaint before your lordship, my lord. May I show you show your lordship the written statement? Written statement of, my lord, the second defendant, because, my lord, the suit so far as the first defendant is concerned, that has been, my lord, settled.
By defendant number 1.
Yes, defendant number 1 has been settled. Today it is being contested by the defendant number 2 alone.
Which written statement? D2.
D2.
Yes.
But kindly come to, my lord, the first paragraph, whether, my lord, the property is wholly tenanted or not. That is, my lord, dealt with. Then paragraph 2, my lord, deals with, my lord, the total area of the property. 3, undisputed.
Area is undisputed.
No, area is disputed, my lord. Paragraph 2, it's not very material. We go by the premises number, my lord. My lord, kindly come to paragraph 6. Page 3. With reference to paragraph 6 of the plaint and the various subparagraphs thereunder, this defendant denies that there was any discussion or negotiation in or about the first week of April 1987 between any of the plaintiffs or the plaintiff number 1 or the defendant number 1 and herself, that is the defendant number 2, or that in July 1987 she orally agreed with the plaintiffs or the defendant number 1 to any of the alleged terms and conditions alleged in subparagraph A to G as alleged hereon. This defendant denies that she agreed for amalgamation of premises number 215 and 217 Netaji Subhash Chandra Bose Road, Kolkata, for the building to be constructed at the said premises, or an additional amount of such and such only from the defendant number 1 or anybody else, etc. Now kindly come to the next paragraph. With reference to paragraph 7 of the plaint and the various subparagraphs thereunder and paragraph 8 of the plaint, this defendant states that, my lord, it is important. This defendant states that on or about 5th August 1987, she was induced by her mother, the defendant number 1, and her advocate, Sri So-and-so, to sign several papers purporting to contain agreements for development of the said two premises, the actual contents whereof were not disclosed to her in spite of request. This defendant was dependent on her mother, the defendant number 1, and did not have the courage to go against her wishes. This defendant never agreed to sell any portion of the said two premises to any of the plaintiffs or the defendant number 3. The defendant number 1, who was managing the affairs of this defendant, aided by her said advocate, compelled this defendant to sign the said papers purporting to contain the said alleged agreement.
Element of compulsion is here.
Yes. I shall make my observations on this, my lord, later on.
No, only first I have to pick out what are the allegations.
Yes. Allegation that the mother forced.
It is
mother aided by the lawyer. This defendant denies that she received any consideration or executed any of the alleged 7 agreements out of her own free will or volition. This defendant states that the alleged agreements are illegal, unconscionable, invalid, not binding on her, and that she has duly avoided the same. Now, my lord, kindly pause here for a moment. Kindly come to, my lord, the last page of the written statement, page 10.
Page 10.
The last page, my lord. Not the verification part, just before that one. My lord, I expected, my lord, I thought, my lord, I won't say I expected, I thought that there would be a prayer for delivery of and cancellation of those documents.
That is not there. No counterclaim is there.
I say that I was forced to execute document. The document is not binding on me. I thought, my lord, that
There should be a counterclaim for cancellation of instrument.
has to be. Otherwise, avoiding a document, my lord, to avoid a document, my lord, under specific relief act, my lord, lordship knows better than me, my lord.
Not so.
Prayer has
Better
to
than
be.
you.
And
so, according to you, this cancellation prayer, the absence of this cancellation prayer, have a serious bearing on this allegation.
Absolutely. And I will show your lordship the evidence. My lord, she was not a minor at that point of time. Maybe she was of a tender age of, my lord, maybe 20, 21, whatever it is, but she was not minor. No, not a single complaint. I'll show your lordship the evidence. She said that, my lord, she has a cousin who is a lawyer. The evidences that would not appear, my lord, from here. She wanted to consult the lawyer, the cousin. First thing is, my lord, that if I say that I have been forced to do something, my lord, I lodge a complaint. Not a single one. This entire case in my respectful submission, I shall go on placing the written statement a few paragraphs. My lord, it would show, my lord, that the entire allegation in the written statement, my lord, in my respectful submission, are nothing but concoction, concocted allegations. She says, kindly come back to, my lord, page 5. Continuation of paragraph 7, my lord, about 5-6 lines from the top of page 5. This defendant denies that she received any consideration or executed any of the alleged 7 agreements out of her own free will or volition.
That is reiterated in paragraph 7 and paragraph 8.
Yes, I shall come to paragraph 8 later on. 7. She says that denies that she received any consideration or executed any of the alleged 7 agreements out of her own free will or volition. Now, well, she received checks.
So, consideration was received.
That is why, well, very craftily, my lord, said, out of my own volition. She cannot deny that she received the money. Now, my lord, it's not, my lord, at that point of time, there was no bank transfer. In fact, my lord, the documents would show that money was given to her by check. She does not say that she did not receive the checks, or somebody else deposited the money in her account.
But she received the checks not out of own volition,
but deposited, encashed, and possibly utilized the proceeds. Now, my lord, kindly come to the next paragraph. Paragraph 8. With reference to paragraphs 9, 10, and 11 of the plaint, this defendant reiterates that she never agreed to sell any portion of the said 2 premises to any of the plaintiffs. This defendant did not receive any part of the alleged earnest money alleged to have been paid by the plaintiffs. Checks. This defendant states that she was compelled to sign the said alleged agreements under compulsion of the defendant number 1 and her advocate. Now, my lord, it's entirely for your lordship to believe or disbelieve. Then kindly come to paragraph. Rest of paragraph 8 is not important. Paragraph 9. With reference to paragraph 12 of the plaint, this defendant denies that she received an alleged sum of rupees 5,000 from the plaintiff in respect of the alleged development as alleged at all. This defendant states that the alleged development agreement is illegal, invalid, unenforceable, inadmissible in evidence for want of registration. Kindly forget that, it's not required. Kindly come to 10. This defendant reiterates the statements made herein above and denies all allegations. Yes, my lord. Paragraph 10. With reference to paragraph 13 of the plaint, this defendant reiterates the statements made herein above and denies all allegations to the contrary. This defendant disputes that the plaintiffs or the defendant number 3 took any step for mutation of the names of the defendants number 1 and 2 as owners of the said premises, or that mutation and recording of the name of this defendant as owner of the said property were due to the efforts of the defendant number 3, or that the said two premises were lawfully amalgamated as alleged or at all. Now, my lord, pausing here for a moment, the properties, two properties, 215 and 217, those were amalgamated, that is, my lord, evidence on record. She says that the plaintiffs did not do anything, or the defendant number 3 did not do anything. She does not say that she did it. But somebody has to do it. Somebody has to take steps for amalgamation. My case is that but the plaintiffs did it. She denies that, but she does not say that she did it. Well, what I am trying to, my lord, show before your lordship is the stand of the defendant number 2.
There was amalgamation.
Yes.
She disputes.
Yes.
Then who has amalgamated? That is your question.
Absolutely.
Then this must be done by.
She ought to have said that no, you did not do it, I did it. I went to the office, I filed the application. No, though that is not there. That is what I am obliged, my lord. That is what I want to say. And my lord, what I am trying to demonstrate before your lordship is, my lord, the stand of, my lord, the defendant number 2. Whether, my lord, this stand can be taken, can be said to be, my lord, a bona fide stand. Then may I continue? This defendant further disputes that the plaintiffs or the defendant number 3 submitted the plan to the municipal authorities or negotiated with any of the tenants of the said premises for vacating the same, or incurred any cost or took any other step or obtained permission for clearance from the Calcutta Improvement Trust or Fire Brigade or Calcutta Municipal Corporation as alleged at all. Then, my lord, kindly omit paragraph 11. With reference to paragraphs 15 and 16 of the plaint, this defendant states that she had nothing to do with the alleged writ petition. This defendant states that the plaintiffs or the defendant number 3 wrongfully utilized the purported power of attorney obtained by them from this defendant to institute the alleged writ proceeding. This defendant denies that the building plan was rejected only on the ground as alleged. Then, my lord, it goes on, my lord. Those are not very important. প্যারাগ্রাফে আছে বলতে যে রিফিউজ করতে kindly give me a minute's time. What could do? No. Now, my lord,
Come to para 14.
Paragraph 14 of the written.
Yes.
Yes.
With reference to paragraph 20 of the plaint.
May I read out?
No occasion for signing such agreement. Which agreement is referred to here?
Well, it kindly come to paragraph 20
of the plaint.
Yes. May I read out?
Which agreement is referred to?
Paragraph 20, my lord, does not speak of any agreement.
Yes.
It speaks of a plan. May I read out? Paragraph
Possibly signature on the plan was proposed
Yes.
at that time.
Then, my lord, since your lordship is at paragraph 20, my lord, kindly also plaint. Kindly also look into paragraph 21 of the plaint and how it has been dealt with. Because one of the issues raised or sought to be raised before your lordship is the question of limitation.
Go ahead with the project of the defendant
Hey.
number 2.
At one stage, the defendant number 1 by a letter dated 20th October 1995 asked the plaintiffs to go ahead with the said project with the defendant number 2 alone. But later on changed her mind and by a letter dated such and such expressed her intention not to proceed further with the said project for development and thereby for the first time on 5th December 1995 refused to abide by the said agreement for sale. Now kindly come to my lord, page 15 of the written statement.
Not page 15, paragraph 15.
Sorry, paragraph 15. I'm sorry. Paragraph 15, page 7. With reference to paragraph 21 of the plaint, this defendant states that she was not aware of the letter dated 5th December 1995 written by the defendant number 1 and does not admit the same. In any event, this defendant states that never the occasion arose to sign and give effect to the alleged development agreement in view of the changed circumstances caused by inter alia, the said amendment of the Calcutta Municipal Act. This defendant reiterates that the alleged sale agreement are illegal, invalid, unenforceable, unconscionable, and not binding upon the defendant. This defendant. Further, the alleged development agreement is otherwise illegal, contrary to the provisions of the West Bengal Building, etc. Act 1993, and not binding on this defendant. Today, we are not on the development agreement. We are on the basis of, my lord, the suit is on the basis of the agreements for sale.
That was executed on
5th August, my lord.
1987, possibly.
87, yes.
Development agreement was signed later on.
No, at the same time.
Simultaneously, it was executed. Both were executed. 6 agreement of sale
and 1 development. My lord, that your lordship would find, my lord, in the plaint.
Para 10.
Yes.
Aforesaid 6 several agreements for sale were executed.
My lord, kindly come to paragraph 7 at page 6 of the plaint.
Aforesaid agreement for sale and agreement for construction
were duly prepared.
5887.
First one is
so all the agreements were executed
on 5th August 1987.
What D1 said, defendant number 1 said on these execution of these agreements?
Well, the dispute with the defendant number 1 was settled. She has sold her share in the property.
It's a kind of coercion that is pleaded.
Same.
Undue influence, rather undue influence.
But she has signed the document. I mean, executed the conveyance.
Their agreement for sale, not conveyance. Agreement for sale only. Agreement for sale. Or
After the suit, she has executed the conveyance.
Defendant number 1.
Yes.
Not defendant number 2.
No.
So far as defendant number 2 is concerned, 6 agreement for sale, 1 development agreement. And please that she was compelled to sign those agreements.
By her mother.
Undue influence, coercion, whatever you may say.
Yes.
And denial that received alleged sum of 5,000.
Gotcha.
Now your point is that when these agreements were obtained by exercise of fraud, coercion, or whatever that might be, there should be a prayer for cancellation of instrument.
According to me, my lord, yes. My lord, it's again, my lord. It's entirely for your lordship to decide.
So that the claim may be credible.
Yes. If I say, my lord, that a document is not binding on me, it's voidable against me.
You must go for cancelling this document.
To be cancelled.
All right. Now point is limitation.
Yes.
This point was raised.
Yes. Now I showed your lordship paragraph 21 of the plaint.
She was not aware of this.
She was not aware. She does not say that she ever avoided, or my lord, she avoided the agreement on any prior date. I proceed on the basis that, my lord, the agreement for sale was avoided on this date, my lord, 5th of December 1995.
When you filed the suit?
Within 3 years. It was initially filed in this honorable court. Then it was transferred to, my lord, the Alipur court. Then again, my lord, under clause 13 of the latest patent, an application was made and the suit was, my lord, transferred back here.
Is it US suit?
Yes, it is US.
But why CS number? CS number?
No, US.
CS number is CS, not US.
US. Yes, 12.
Oh, this was originally filed as CS
Oh,
137.
it was originally filed, yes.
Thereafter, it was transferred.
Thereafter, it was transferred and then it became...
Yes, when it was written statement was filed, it was US.
Yes.
At the time of filing written statement, it became US. Yes.
Now, my lord, as I was submitting on the question of limitation, my lord, I have, my lord, said that the refusal on a particular date, and I have filed the suit within 3 years from that date. There is nothing to show, or there is no evidence on record to show that, my lord, they refused performance of the agreement prior to this date.
Come on the next we will hear evidence. Heard Mr. Mitro, the learned senior counsel in part. Fifth is okay, 5th March? Fixed 5th March for further argument.
Only one thing, Mr. My learned senior friend will certainly indicate. The 6 agreements were...
My lord, kindly don't keep it on 5th, my lord. There is a, my lord, criminal contempt matter against, my lord, lawyers of Bushirat Court, my lord. I am appearing there for the lawyers.
Criminal contempt against lawyers of Bushirat Court? Here?
Yes, my lord, before a division bench. And it is
What
fixed.
happened?
The normal thing. I won't...
These agitations. I was never posted in Basirat, but...
Your lordship is aware.
Aware of.
Only one thing, my
I am
lord.
holding the brief, my lord.
One thing, the 6 agreements
There
were...
is a very big difference in the ground reality. What is prevails in High Court, what prevails in Bar Library Club, what prevails elsewhere.
Yes.
In some parts of the district.
Yeah, absolutely.
Not wholly. Some parts of the district are very peaceful.
Some.
Absolutely.
This is my experience show. Only the.
So kindly don't keep it on 5th any other day, my lord. I really do not know.
6, 7.
7th, my lord.
7th March. Only one thing, my lord, what I was saying, those agreements were executed in favor of the plaintiff number 1 to 4 and the plaintiff number 1 to 4 and the development agreement was in favor of the defendant number 3.
What's that?
That's all.
Lord, what should I say?
7 to 7.
For solution, item number 9.
I had made my submission. It was not formally concluded. I had given my notes and also my judgments. Here, my lord, the issue is whether the counter.
You have received 10 lakhs.
I had received 10 lakhs.
10
my
or
lord.
13 lakhs?
No.
10 lakh. 13 lakhs.
They had received 15 lakh from me as in way of a loan advance.
So thereafter, winding up.
After Supreme Court order passed.
Supreme Court initially asked them to deposit 13 lakh because that was the amount on basis of which the winding up petition was admitted. So then they deposited the 13 lakh. Then for the time being, we entered into a settlement saying that very well, the winding up will not continue. I will withdraw 10 lakh out of that 3 lakh. They will withdraw 3 lakh. So far as my balance claim was concerned, I am to pursue my remedies in law, which is what I did.
The issue here is that before the Supreme Court, it was according to us, it was a full and final settlement. That's why we took back 3 lakhs and they took back and they got 10 lakhs. 10 lakh rupees they retained. Otherwise, there would have been the entire money would have possibly gone to them. And there cannot be a settlement for the time being. And if at all, before the Supreme Court was in relation to a winding up petition. So once the winding up petition is disposed of, and if at all the party who is the petitioner in the winding up court has any further remedy left.
Supreme Court, let me see the Supreme Court order.
My lord, kindly sees the Supreme Court order. In fact, it is part of the compilation of judgments because it is now also reported. It's also reported judgment. Compilation to my lord.
Which judgment you are referring to?
This is 2013 10 SCC 543. Bhasha Construction and Industrial Projects Private Limited versus Shining Vyapar Private Limited. This, my lord, is part of the compilation that we have given and also referred to the notes of argument. It's the unreported, my lord, version is also exhibited.
Where is it?
Right. My lord, I have a separate.
Yes, Bhasha context is first.
Very first judgment, my lord.
First judgment. May I just read out this judgment? Leave
the respondent is permitted to withdraw 10 lakhs and remaining 3 lakhs to be returned to the appellant.
To the appellant.
Shall be dropped. Winding up shall be dropped.
Shall be dropped.
Shall be expedited. That is, it should continue.
Now, the suit. My point here is that the suit, which at that point of time was pending, was my suit. That is the appellant before the Supreme Court, as against the defendant number 3. Because my principal claim was against the defendant number 3 in the suit.
This suit is filed by you?
By me. My principal relief claimed is against the defendant number 3. What was the relief claim? That I'm entitled to receive sum of money from the defendant number 3. Against defendant number 1 and 2, my claim was declaration that till such time D3 makes me payment, I'm D1. I'm not liable to make payment to D1 and 2. So there was no counterclaim at that point of time. So because of the settlement, it has also been recorded in a subsequent order of this honorable court, my lord, by the coordinate bench, that I am not willing to proceed with my suit against the said defendant number 3. The settlement has been reached, and that is recorded in the order, which I have also indicated in my notes of argument. My lord kindly sees the order dated. Yes, this is a 13th of
page
6th of February 2020.
Page
6th February 2020 order, my lord, separately.
Where is that order?
6th February 2020 order. So this order was. The order is 6 February 2020. 6 February 2020, suited. 2020, 6 February. order sheet আছে দেখে আমাকে ছিল order sheet আমাকে পেয়েছি। দেখছি গো। May I, my lord, have a look at whether this is possibly this is the order. Entire. Yes, this is the order. But kindly sees, my lord, the last first paragraph, the last sentence. In fact, the previous it also shows that against D2 also has received its payment. Cross-examination. Deposition cross-examination.
Defendant number 3, they are not pursuing in defendant number 3.
3, because my principal claim, my lord will see my plaint. My principal relief money claim was against the defendant number 3. And against the other defendants were a declaratory relief. I had no other separate. My case was that because there was an agreement that D3 will return me the money, and once I receive money from D3.
Now plaintiffs submit they are not proceeding with respect of defendant number 3.
Defendant number 3. That is my principal claim. So I'm not proceeding with defendant number 3. Apropos defendant number 1, already a settlement was reached before the Supreme Court. That is the evidence which has been led by the plaintiff, both in chief.
So far as defendant number 2 is concerned?
2 is concerned, my lord. Also 2 has received its whatever
in
money.
Separate suit.
Separately, it has been settlement has received.
Now defendant number 3 has raised a claim against you.
Now defendant number 1 has raised a claim against one of the plaintiffs. Plaintiff number 2 in the counterclaim.
In the counterclaim.
So whether at all
that is defendant number 2.
That is defendant number 1 as against the plaintiff number 2. Yes, defendant number 1 as against the plaintiff number 2. Now, defendant number 1 was the petitioner in the winding up petition. The exact what is the cause of action in the counterclaim is was the cause of action before the winding up court. Defendant number 2 files a winding up petition, it gets admitted. Ultimately, I go up to Supreme Court. I don't succeed in the appeal court, I go up to Supreme Court. Supreme Court directs me initially to deposit 13 lakhs. Once my matter is before the Supreme Court, there is a settlement reached. Now, settlement, since it is not in writing between the parties, whatever is the order of court, my lord, the settlement is reflected. Settlement is reflected that they will be entitled to take 10 lakh rupees out of the money which has been deposited, and I'll take back 3 lakh rupees. And the suit which was filed at that point of time by the plaintiff against the defendant number 3, where principal claim was there, where there was no counterclaim, that suit can be proceeded with. Now, since I have reached a settlement with D1, I was not proceeding against D1. With D3 also, I abandoned my suit because I believe that since the settlement has been reached, D2 also as everything has been done, D3 I will not proceed with that particular claim of mine. That's because of the settlement. Now, counterclaim filed subsequently, where the pleading is that after the Supreme Court order, we are now entitled to lodge a counterclaim. Now, if at all there was a right, the right of pursuing this counterclaim was at all alive, that would have been recorded in the Supreme Court's order. Because today the Supreme Court...
So your point is this counterclaim is not to be entertained.
Cannot be entertained, is barred by estoppel by judgment. Estoppel because they have received full and final payment. Once full and final payment received on a settlement recorded in a Supreme Court order, now they can't have a cause of action for counterclaim which is arising out of the winding up petition wherein the settlement was reached.
Have you filed any notes of argument?
I have filed, my lord, my notes of argument. I believe on notes starts. Because in the previous occasion I had filed, I'm also carrying, my lord, a separate copy of the notes. Oh, but then it's not in the full cost title. That's why. But otherwise, my lord, I had filed a compilation also. I had filed. If it is not there, my lord, I can hand up. Yes, notes of argument of the print of the.
Let me go through it. Come on the next day, let me go through it in the meantime.
And then the next day, may I reply, my lord, to my lord, Mr. Mailon?
If I need any clarification, I will ask him.
Yes,
Because
otherwise, my
I
lord,
have to read it first.
yes, of course, my lord.
By the defendant, I will make the submission.
Heard in part, adjourned to.
May I just indicate two things from the Supreme Court judgment so that
Come on
may
the next day. Let this part be finished. 5th March.
But I'll take it, my lord, that I will argue if anything is required from Mr. Bhattacharya, that he'll make his submission.
I have not formally, but if your lordship, my lord, requires.
Let me give him one day opportunity.
Yes, my lord, I'll make my submissions later on the. Great.
Then you come with the next step with your answer.
Grateful, my lord.
Next.
My lord, at 2 p.m., my lord, on
2 p.m.
Great.
Regular list, item number 18. In the goods of Rita Mukherjee. I am appearing on behalf of the defendant, your lord.
Probate proceeding, my lord, there was the caveator was arguing.
My lord, I am being led by Mr. Sengupta. He is there.
You were led by?
Mr. Shenmugh.
So I'm the defendant, your lordship, in the probate proceedings. Lordship, on the last occasion, your lordship, we have shown, your lordship, 2 or 3 important things. Probate application.
Let me see the witness action.
Yes, your lordship. Lordship has seen the
Statement of witnesses.
deposition of the attesting witness. The second one, your lordship, is the deposition of your lordship an advocate, who is the advocate on record, your lordship, of the other side. Third one, your lordship, was actually looking, your lordship, this deposition of the propounder. The reason, your lordship, is before showing
he was not aware of the thing. He was not present at that.
He was not aware of the thing. So therefore, the suspicious circumstances, which
How
has
within
been
within half an hour, the matter reached from
Madhyamgram
to Calcutta.
To RA, your lordship, near Governor House.
Sukumar Banerjee is the attesting witness.
Yes, your lordship, is the attesting witness.
Which questions are to be looked into?
Your lordship kindly sees the important question which was there. Question number 43 onwards. Yes. Lordship kindly sees question number 36 first in the chief. In answer to question number 24, you have said the execution of the will took place at 9 a.m. Are you in a position to clarify this? On that date, I was present there from 9 a.m. The signature and execution of the will were made at 10:30 a.m. So he has mentioned, your lordship, the time. Now, in the cross-examination, your lordship kindly sees question number 44. As you deposed, you reached at the premises Nandan Kanur, PO such and such, District North 24 Parganas, at the residence of Rita Mukherjee at 9 a.m. and the execution were completed at 10:30 a.m. Am I correct? He said, yes, that is so. Who were present at the time of the execution of the alleged will? There were 4 persons, including Rita Mukherjee, at the time of the execution of the will. One was Rita Mukherjee, another person as an advocate, as Rita Mukherjee told me earlier, myself, and there was another witness. I do not remember his name now. Are you aware of any person, namely Ranjit Bonik? He was the second attesting witness. Yes. What was the age of Rita Mukherjee on 9th of March 2017? It was very difficult for me to say her exact age. How was the health condition of Rita Mukherjee at the time of the alleged will? She was quite healthy and fit. Can you indicate what happened after the signature on the will on 19th of December? After this date, once or twice I had asked her about the will. We had talks during the time. Did Rita Mukherjee tell you? This is also very important. Can you do what happened after the signature on the will on 19th December 2009. It happened on 10:30.
Signed, when did he put his signature?
10:30. He said, Your Lordship, that it
Just
has
a minute,
been.
let me go through.
Yes, sir. Question number 44, Your Lordship, kindly says.
Attestation part. Where is the attestation part? Which questions?
Attestation part, Your Lordship, he asked. Question number 36. That is in examination in chief. And then, Your Lordship, I was showing question number 49. Can you indicate what happened after the signature of the alleged will on 19th of December 2009? I specifically asked this question. After this date, once or twice, I asked her about the will. We had a few talks during that time. So after 10:30, they were making conversations. Did Rita Mukherjee tell you anything about the registration of the will? He said no. Immediately after the execution of the will, what was the discussion between you and Rita Mukherjee at her residence? After execution of the will, I had just asked her about her health condition. I suggest to you that you left the premises.
Yes, that is there.
Yes, at 1 o'clock on that date. Not a fact. Then Your Lordship is say, at what time you had leave the residence of Rita Mukherjee on that date? At around 11:30 to 11:35 a.m. I left the residence of Rita Mukherjee. Can you tell how much time usually takes from Madhyamgram to High Court? I cannot say this as my office is in Gigandeep. I usually travel to the office by metro station. I suggest to you that the alleged will of Rita Mukherjee was presented before the registration office at around 11:30 a.m. on that date. I do not know. And this man did not, Your Lordship, come in re-examination. And even on the next date, Your
Just a
Lordship.
minute.
Yes, I'm sorry. কুমার পরের দিন Yes. So he didn't actually come, Lordship, regarding the re-examination and clarify the position. That what happened? 10:30 you did, 11:30 you left the house, and during that particular period of time, he specifically deposed that we had a conversation with Rita Mukherjee. He understood. He didn't come. Then suddenly, the advocate on record of the other side, Mr. Mondol, he has gone into the witness box because the main Lordship, the propounder, he has to actually Lordship, remove the suspicious circumstances. That is the main ground. Otherwise, the will fall. Now, Your Lordship kindly sees his deposition of Mr. Mondol.
That you showed last date.
Yes, I have shown Your Lordship, and if I have shown Your Lordship the important question just once, Your Lordship, I need to show Your Lordship the important things.
She explained this.
No, he did not explain. He said 10:30.
No, give some explanation like 9 a.m. 9 a.m. execution took place 10, 10, 12, so and so.
No, he said 10:30 it has been executed. His Lordship kindly takes once question number 6 onwards. That's Your Lordship, the examination in chief. And my cross-examination. My cross-examination starts from question number 37. May I only, Your Lordship, from question number 37, Your Lordship, may I just read it? When did you meet Mrs. Rita Mukherjee?
Question number 37.
Question number 37 starts from my cross-examination. When did you meet Mrs. Rita Mukherjee for the first time? I do not remember the exact day. Almost 10 days before the registration of the will, I met with Rita Mukherjee for the first time. He said 10 days before, because I have shown that there is a date, Your Lordship, of September 2019, which has been, Your Lordship, deleted. Is this correct? That
Is
is
you argued last date.
Lordship, I have shown.
Now with the notes of argument next date.
I'll include it, Your Lordship. Then page 42, question number 42, what happened from 11 a.m. to 11:30 before the presentation? Within 11 to 11:13, signatures, photographs, he has said. So from 10:30 to 11 o'clock, he came from, Your Lordship, Madhyamgram to Rajbhavan. Impossible. On a Saturday. And the time is 10:30. That is also very important. You can do it at night. Now, why this particular person's, Your Lordship, the deposition should not be taken into consideration? Lordship, kindly
notes of argument. I got your point. Come with the notes of argument.
I'll come with the notes. Only one question. Very interesting, yours. That was a Saturday. So I asked him after the completion what you have done. He said, I have come to the High Court. So these particular credentials, Your Lordship, actually should be seen at the time. And two things very important. Why? I have shown Your Lordship the will where, Your Lordship, the date of time of presentation was 11:30.
Where it is stated, I came to High Court.
Yes, Your Lordship. Then question number 57. Lal Ratan Mandal.
Where is that question?
Yes, Your Lordship. Kindly take, you are a busy lawyer. Question number 59. And therefore, no re-examination to clarify this situation.
All right. You come with the notes of argument.
Yes, Your Lordship.
Heard Mr. Shengupta in part adjourned to 11th March.
So I would like to, Your Lordship, place certain judgments also, Your Lordship.
Come with the notes of argument and with the compilation of judgment.
I'm grateful.
Obliged.
Witness action, item number 19.
Lordship, I'm for the plaintiff in this matter.
Witness is there or not?
No, my lord.
The
For
witness is
some,
not there. I had mentioned this matter yesterday, where I had mentioned on notice, but because my learned friend on the other side was not present, my lord was of the opinion that it should appear today, and I should re-inform my lord that owing to a few want of documents that we have applied for certified copies, my lord.
On prayer of the learned counsel for the plaintiff, witness action is adjourned to
Lordship, joint prayer, Lordship.
24th March.
Grateful.
Extremely obliged.
20টা তো 24th মার্চ করে দাও। ঠিক আছে 20 সকালেই বলে গেল না
24 March
25th March ওটা ছিল না
25th March
no 24th your is 24th
extremely obliged
Grateful.
Company matters, item number 21.
I am appealing for official liquidation. On the last
This
question,
matter,
report,
wait don't be in haste
yes
now you will argue Mr. Jha
Only a matter of disbursement.
Yes.
Already the proportions have been decided.
who is for
by-
liquidator
I am for happy. I am appealing for liquidation.
I'll make it very simple, my lord, for your lordship. My lord, there is a previous order. The previous order, my lord, provides for, my lord, the pro rata distribution to be made. IAPF for a secured creator, my lord, so far as
You are
I-
for?
for one secured creator, my lord.
Your
I
name?
have understood it. TPG.
Where is the application of official liquidator?
We have filed a report with certain payers similar for disbursement and for sale of the unsold property, and a maps will be prepared.
TPG equity amount of claim 176 something and already settled 48 something.
48 crores is, my lord, what has been, my lord, is the preferential claim that is settled. 127 crores is, my lord, not the preferential. It's a, my lord, claim computed, but, my lord, not the preferential claim. Preferential claim has been admitted for the sum of 48 crores.
What is the amount in hand?
My lord, kindly come to paragraph 12, my lord. Paragraph 12.
Now come to this chart.
Yes, yes, yes.
Paragraph 12.
Yes.
That is more conspicuous. Yes. EPF amount of claim 2 crore 65 lakhs. Then TPG, that is you, Mr. Shah.
Yes, sir.
Your amount is, your claim is 48 lakhs, 48 crores.
My lord, out of that, we have been already made some payment. My lord, now, my lord, the present balance is 45 crores, 19,75,000. And my lord, the pro rata, my lord, payment to be made to us under section 15 and 5 is about 18 crores, 49 lakhs.
What amount is to be paid to you?
My lord, pro rata, my lord, under 529A, if your lordship is looking at the chart at page 8.
48.
My lord, total was 48, 299 has been paid. Remaining is 45.90.
48 amount of claim is 176.
Yes, my lord, but my lord, the preferential claim that is admitted, my lord, if your lordship is, my lord, looking at the, my lord, please see, my lord, 176, my lord, settled as preferential is 48.80. Well, I'm confining myself to that for the time being.
Already settled as a preferential under section 530, 127.
530, my lord, I'm not going now because 530 will stand, my lord, in the lower stage of priority.
But you have got this money, you have received this money.
Well, it is a claim that is settled. Well, there are two, my lord, settlements. Well, total claim is 176 crores.
48 and 127.
That's right. Now, well, 48, out of that 48, if your lordship kindly comes down to page 8 of the report. Out of this 48, my lord, I have been paid 299. The balance is
Ad hoc
45.
basis 299 has been paid to you.
Right.
So 45 is now balance.
And my lord, in terms of the earlier formula that was derived by this honorable court in a prior order, my lord, 529A, my lord, order of priorities, I am to get a further amount of 18 crores 49, 38, 389 from out of the funds that are lying in hand of the.
What about the money of EPF?
Well, PPF is 2 crore something. Well, kindly come to paragraph 12 in its first portion.
How do you pay
number
EPF?
Page number 7. Kindly come to page number 7. We have said apart of this amount.
Page 7, yes.
Paragraph 12.
$265 may require to set apart.
Yes.
Why you want to pay it to EPF?
Well, it has not been yet settled. Well, kindly come to the next. Kindly come to
You
the
are for EPF.
Kindly come to page 5. Page 5, it has not been settled as yet.
Very good. It is not settled. This amount without prejudice to anyone's right, this will be paid to EPF. If something is overpaid, it will be called back.
It is very difficult situation.
I can't understand why a government organization should not be paid money.
No.
First thing, this claim was pending since long. It should be settled. So at least pay 2 crore, leaving 65.
That is up to your lordship. We have stated that that amount has not been settled. And
without prejudice to anyone's right,
yes,
you pay an ad hoc amount of rupees 2 crore to EPF.
That is up to your lordship. If your lordship may detect, we shall see you.
Then come with a report how much is balance, how much is in your hand.
Well,
so that this
paragraph 12, paragraph 12.
12 million paragraph
Yes.
12.
Even if they set apart this amount that they said should be set apart, my lord, the balance, my lord, has been computed. And my lord, our payment
You will still get 18 crore.
Yes. 49 lakhs and what?
Well, that is after setting apart. After setting apart, my lord, the sum. My lord, in paragraph 12, 2 crore 65 lakhs 82,591. The balance would, my lord.
Now you come with one thing, auditor's report. This
Well,
is your-
I have annexed the report, my lord.
Where is that?
Page 43. And you also directed on the last location, that is why. Page 43.
What is this?
So these are accounts, blood. You'll also directed what are the liabilities and what are the assets at this present moment. You'll also directed. So that is why you have made these accounts for the time being. And blood, this is it.
No, I can't understand. One thing is not comprehensible by me. You filed with the compilation one statement of accounts. What is the authenticity? Not a single signature is there. And you are nodding your head. I can't understand this.
It should be authenticated by the.
No, why did you came with this thing? Why did you file? How do you dare to file this thing? Who signed this verification? Where is that order? Earlier order.
Well, earlier page first annexure. Kindly come to page 11.
In terms of order dated 12 December 2024,
Yes.
this court directed the official liquidator to furnish statement of accounts showing available funds, pending liabilities, and income, along with others. A copy of our statement of accounts is here without being signed by any person. Who signed this?
The application is signed by the official liquidator.
The official liquidator must be present on the next date with the audited statement of accounts from 31/12/92 to 30/11/2024 and shall explain why duly signed and authenticated statement of accounts has not been placed before this court. Let the matter appear in the list on.
Well, I understand the subject, of course, to correction that there is no system of auditing the accounts.
At the time of liquidation, that must be there. But when they're raising certain claims, this late credence, the statement is there.
There is a prior, my lord, order of this honorable court following a report filed by the liquidator in the 2011.
2011 is one thing, 2024 is another thing.
Of course.
And there is no reason why an authenticated statement should not be obtained by the court. When official liquidator is submitting something, in another matter, official liquidator has filed a report. I only asked what is the due to State Bank of India. Nothing is there. Reiterated that this was paid. That practice should be followed.
Yes, my lord, in that case, my lord, let it be authenticated by the bankers. Well, instead of
not bankers, by any auditors, panel auditors are there. Let it be signed at least by the official liquidator. Let him take the responsibility.
Let the official liquidator
countersign.
Yes.
Authenticated. Well,
Let him come with the statement, authenticated statement.
With regards to, subject to correction, with regards to paragraph 12, where they have set down, Millard, whatever is due to be paid, Millard.
Come next day. I'm giving you 7 days time.
The amount is crystallized, whatever is there in the
Kindly
hand.
keeps it on a shorter date, Millard. We are Millard standing at the way Millard to receive the money.
Instead of audit, kindly authenticate.
Authenticated. 3rd March.
Could it be 6th March? I am in some difficulty on 3rd.
Yes, 6th March.
In the meantime, they would also consider, Millard, the EPF, whether it has been settled or not, Millard, because my instructions are EPF amount was settled. And we have got
EPF amount will be paid. If it is overpaid, they will ask to return the balance, but you have already admitted 2.65 is the amount.
It has not been admitted. It has been set apart only.
Let it be paid to EPF.
Very well.
If at any point of time it was found that the EPF was overpaid, they will ask to refund.
Absolutely.
No problem. Very good. Leave, sir.
22. 22.
Will kindly consider if Miller will pass an order, even indicating this that the
One
EPF
liner.
amount can be paid.
No, come on the next date. Remind me, I
Very
pass order.
Your Lordship, UP Singh, senior advocate, is leading me. He may be allowed in the panelist, Your Lordship. He's been denied
এই যে অর্ডার
in the
গুলো
panelist.
1 2
UP Singh
3
পুরো
4
হ্যাঁ?
5 6 7 8 9 10
উনি
প্রত্যেকটা অর্ডার
জানেন
আমি সই
তো
করে
আছে
যাব
না।
প্রত্যেকটা অর্ডার যেন আপলোড হয় আজকে
अरे वो नहीं किया है उनको
যখন
अभी।
10টা ম্যাটার রাখা হয়েছে 10টা ম্যাটার আমাকে দিয়ে করানো হচ্ছে তোমরা থাকবে যতক্ষণ আপলোড হচ্ছে এটা ইট ইজ মাই ম্যান্ডেট কিপ ইট ইন ইউর মাইন্ড আমি যখন মামলা শুনবো প্রত্যেকটা অর্ডার আপলোড হবে তারপর বাড়ি যাবে আদারওয়াইজ আই উইল পাস জুডিশিয়াল অর্ডার এগেইনস্ট ইচ অফ দেম
Lord, please see the order of 9 January 2025. Lord, there was an order which was earlier passed on November 2019.
আর আমাকে না বলে কেউ যেন বাড়ি না যায় কোনটা which one
Lord, item number 22.
Yes.
Lordship will please have a look at the order of 9 January 2025. Lord, the state of Bihar is represented today. My Lord, I was essentially praying for, my Lord, an order for compliance of, my Lord, an order which was already passed.
Who is for the state of Bihar?
Your Lordship, I am for the state of Bihar, led by Mr. Learned Senior UP Singh. He's online, Your Lordship.
Now, which order is to be complied with?
My Lord, there's an
Your
order
Lordship,
date-
we are filing an affidavit. This CP was dismissed, Your Lordship. So,
Let me see.
Your Lordship, we have annexed the order as well.
An
which
affidavit
at
is
page
filed
13.
on behalf of the state of Bihar. Let the copy be served.
I've served, Your Lordship.
serving me
Page
right
Would you
here
like to
13.
file any affidavit
Yes,
against
my Lord,
this?
I wish
Page
to file.
13 is the order that states that
We sought to
company
file
petition
affidavit in
already
opposition,
dismissed.
counter affidavit by the learned counsel for the.
Lord, 7 days, my Lord.
You are for
My Lord, I'm for the applicant. My Lord,
For the applicant.
liquidator. Yes.
affidavit in opposition or counter affidavit shall be filed on or before the returnable date. Let the matter appear in the list on
Your Lordship, if it could be
18th March.
My Lord, 18. Great.
My application, my Lord, I'm led by Mr.
23,
Devashish.
but may I?
behalf of the official pursuant to your lordship's direction, lordship, I am filing a report, lordship.
But I have taken out an application in the judges. I have taken out an application in the judges' summons. The date was mentioned as today, but when I'm told the file has not come, and the application is also not there in the list. My application number is CA 21 of 2025. I'm praying for recalling of one of your.
This is IACA number 20 of 2014. Is filed by
And
whom?
that's my application, my Lord.
That is my application, my Lord. I'm leading Mr. Nondi, waiting for the applicant, my Lord. Your Lordship is aware of the fact that on the last occasion, your Lordship was pleased to direct the official liquidator to hold a meeting with the joint receivers to find out whether there could be a demarcation of the land, the leasehold land and the freehold land. Now, today I believe that the official liquidator has filed its report. Insofar as I am aware, my Lord, the official liquidator does not a copy has not been served on us, but it appears not the official liquidator has not passed any suggestion as to whether or not there can be a demarcation of the land between the freehold land and the leasehold land. But may I make myself very absolutely clear that my clients are not at all interested in the leasehold land, which is the subject matter of the property or asset of the company in liquidation, and which was sold to the auction purchaser. My only short grievance is, which has been recorded in various orders passed by this
What is
honorable
your
court.
opinion on the report?
Sir, Rajiv Lal is getting.
I am appearing, my Lord, on behalf of the official. Your Lordship will kindly take my report, page 14, my Lord, 1-4.
No, what is in the report? These are annexures.
Yes, my Lord. We've had meetings. We've also had the inspection carried out. There was certain information that were required to be provided to us as to who are the occupants of the property in question.
So it is
We
not
are-
complete.
No, it is complete, my lord. As far as we are concerned, it is complete. All that we needed for them was to identify that, all right, these are the occupiers, so that we can give them notice and have them evicted. Because we need to bring them on record. Your lordship will kindly take the minutes that we've had, my lord. For a moment, kindly take page 14, my lord.
Yes, I've seen that. Now,
You
what
know,
is
now, I'm sorry, my lord.
of your any report?
The report, my lord, we are willing to bifurcate it. The only difficulty that we are facing over there is that there are so many trespassers and illegal occupiers. We are unable to identify who they are and by what virtue they are there. That was the information that we had sought from the joint receivers, and the joint receivers had told us that yes, we will give you the information so that you can take necessary steps and get orders for their eviction. We are in principle absolutely in agreement with what Mr.
No, this
Kundu
is a
said.
long story.
No, my lord, we have been trying this for, I don't know, umpteen years. The difficulty is that every time we go there, now there is an application that has been filed by one Mr. Dakalia, your lordship. This is what has been mentioned. Now, he has now come up to say that he has a right title interest in the property.
That
Now,
can be decided by the company court.
Very well.
I appear for in support of that application. What I am praying is for recalling of your lordship's order of 16 January 2025.
No, without serving a copy,
I do not know what the-
but we are the applicants in our application.
I have served the official
respondent
liquidator.
number two.
In what capacity is
My lord, I have served the
You are
official
respondent number 2.
No, my lord. I appear
No,
for
he's not even a party.
one
No, no,
Sumati
no.
Chand Dakalia. I appear for one Sumati Chand Dakalia, who has also filed a suit. That suit is pending before your lordship.
What is your application number?
Well, 21 of 2025, which is not there in the list when it's supposed to be
Let it
listed.
come on the list. On that date, it will be taken up.
My lord. And my lord, that
Now, so far as
clearly-
your official liquidator is concerned, what do you have to say right now?
My lord, we are giving the demarcation in the manner that we have gone and inspected. There is no difficulty with that. And there is also no dispute about the fact that yes, the plan that has been given by
We have to ascertain the names.
That's right. We have to get a specific orders for eviction, because what is now happening is they're all standing up in collusion and saying that no, you cannot do this. Every time we have gone, we have faced resistance.
My only prayer to your lordship is, my lord, that being the victim of the conspiracy between Interchief, the auction purchaser, and or its trespassers who have been inducted.
The
who have
official
been
liquidator
inducted
has
in
submitted
property.
a report. Have you served copies?
No, we have not.
No, we have not. Copy may be served on the parties.
My colleague is there, my lord, she will serve it.
According to Mr. Lal, the learned counsel for the official liquidator, some further steps are to be taken against the occupiers, for which he is in the process of ascertaining such names. The official liquidator shall take necessary steps in this regard for getting the property unencumbered and take necessary steps. Full stop.
May I interrupt only once? Well, the official liquidator, the order was the official liquidator will inspect the property. Well, there are there are various receivers. Well, in my suit, there are two joint
I'm
receivers.
not concerned with your
No,
suit.
well,
I'm
well,
passing
what
directly
I'm
to
saying
the
is-
official
We are not even party in the suit also.
It's with
Then
the
you
same
will
property. It's with the same property. Well, I'm claiming
Mr.
ownership
Thakur,
of
what
that
is your
property.
application?
Well, that is CA 566, the one we have lordship, Lord.
Yes.
I'm led by Mr. Kundu, Lord. There we have paid for demarcation of the property, Lord.
Yes.
One large property, 7 acres and odd,
in so far
out
as-
of which, Lord, 3 acres and odd has been given to the company in liquidation by way of a lease. And that has been sold. See, as I understand from my
Liquidation
learned
cannot be ascertained. Liquidation cannot be done according to Mr. Lal because so many squatters are there or occupiers are there.
That is Lord, by reason of the official liquidator, when they have handed over, they have sold 3 acres and odd, and they have handed over 7 acres and odd. That's the problem that was created by the official liquidator long back. Now we have paid for demarcation. We went to them, my lord. They said we'll have a joint inspection. They said no, these are trespassers. It appears that they have been inducted by the auction purchaser. Auction purchaser has not executed a deed in their favor from the official liquidator.
So what is the solution?
So
Well,
my lord,
may-
we
may-
said that
may-
you demarcate.
Well, may I indicate, Mr. Lordships?
Mr. Lal.
Your
May I-
Lordship,
may I- may I
the
interject,
order
Milord?
dated
Milord?
16th of August 2024 passed by the Honorable
I
Court.
cannot in a position to hear now.
Milord,
I cannot
Milord,
hear Mr. Kundu properly, so I will hear you and I will hear Mr. Lal.
Your lordship,
Yes,
can you
Milord.
give me
Your
2
Lordship,
minutes,
can you-
Milord? I think this matter can be solved. Just give me 2 minutes, Milord.
Yes.
The issue, Milord, there is a clear collusion between the auction purchaser and the occupants in the property. There is no doubt about it. They've all been set up there. If the title of Comsource, who's the auction purchaser, he has not perfected his title. If his title is not perfect, he can't pass on a better title than anybody than himself. He has.
So what
gone
will you
on
do
and-
right now? So what will you like to do right now?
May our directions may be passed by your
Part in
lordship.
part adjourned to 24th March.
Your
May
lordship,
may
may
may make one
24th March, may my application be listed.
Your application number?
21 of CA 21 of 2025.
CA 21 of
2025.
2025 may be taken up on that date.
And the report of the official liquidator may be.
That's all. Next matter.
And my lord,
Make a
kindly
request and
direct
official
them-
liquidator will come.
My lord, kindly direct them to serve a copy of that application. It's in my application, they are with a
But I've
moving
served the
without
official
service.
liquidator. My lord, if they want a
Yes,
copy,
serve a
my lord,
copy.
they can intervene. My lord.
No question of
But I've
intervention.
served the official
My lord, he's
liquidator, who is
praying for
the necessary party. My lord,
My lord,
party here?
No, he's
Can't be a
praying
party
for
within
a
my
stay of an order passed by your lordship
Let
in my
this be filed.
application.
If necessary, I will hear you. This copy will be served upon you.
Lordship.
Come on the next date.
24.
Respondent number 2, it may be recorded, my lord.
Give a
in
note.
the meantime,
How they appear.
DXC
24.
copy of the report by the official liquidator.
প্রত্যেকটা
Yes,
order
yes.
upload হয়ে
Mr.
আছে।
Kundu, I shall ensure
Everybody
that.
have
I
it.
shall ensure that.
না না কোনো ভুলের ব্যাপার নয়, মামলা রাখতেই হবে করবার জন্য, কিন্তু প্রত্যেক দিনের মামলা প্রত্যেক দিন আপলোড হবে। অর্ধেক মামলা করে দিয়ে বাড়ি পালিয়েও 5টার সময় এটা যেন না হয়। কল রেজিস্টার অরিজিনাল সাইট, রেজিস্টার ওএস কে ডাকো, ওএস এ চার্জ যে আছে তাকে ডাকো। 24?
Yes,
Should
my lord,
I
I am
appear
for
for
the
this?
official liquidator, my lord, your lordship's last location, was lordship, or please to direct me to file a report with regard to the sale in respect of the immovable property which was situated at Orly, Mumbai Orly. My lord, if your lordships kindly see the first order which was passed by the lordship's coordination bench, page 7. My lord, on that order, my lord, the sale was confirmed.
Now what to do?
Now, my lord, your lordships kindly turns to the order, next order dated page 10, my lord.
Page 10, 3rd October 24.
Yes, my lord.
Yes.
In that order, my lord, your lordships, there was a direction that official liquidator will not disburse. Now, kindly first come to page 8. I'm sorry, my lord, page 8, my lord, the sale amount, my lord, this is the third paragraph of this page 8. 3,16,25,000 has been obtained, my lord. That was the sale price.
Page?
Page, my lord, 8.
316.25.
Yes, that was the sale price, my lord.
Where is that money?
My lord, that money is lying with the official liquidator. Then, my lord, kindly see the pay.
What do you want to do with this money?
My lord, that amount, my lord, your lordship kindly turns to page 16. My lord, I have accounted for, my lord, I have shown the accounts. There were page 16 is the total amount received, and my lord, the disbursed.
Again, unsigned statement.
And my lord, the page 17, kindly see. The amount.
Are you certifying that this is a true account?
My
It
lord,
is not signed.
My lord,
You take
No,
responsibility.
your lordship is absolutely correct. It should be signed by the official liquidator. Definitely signed by the official liquidator.
Then who will take responsibility?
Yes, my
Why
lord.
this court will pass order on the basis of this one?
Very well, my lord, your lordship kindly.
The official liquidator,
Yes.
the learned counsel for the official liquidator has submitted report in terms of previous order dated
My lord, that was the order dated 12 September 2024.
12 September 2024. Annexing therewith a statement of account which is not signed or authenticated by the official liquidator. The official liquidator must authenticate the statement and place it before this court. It is official liquidator is directed hereby not to place any statement of accounts without authenticating it by putting his signature or any person authorized by him. A copy of this order may be communicated to the official liquidator. Official liquidator shall be personally present on the next date with a report and authenticated statement of accounts on 24th March.
My lord, one small submission. I am the sole financial creditor in this matter. My lord, as per my lord's order of 12th of September 2024, there was a compliance on our part to submit a claim before the official liquidator. We had submitted the claim, the hearing had taken place, we had submitted documents as well. My lord, they were supposed to adjudicate the claim by and within 1 month of submission of the
official
bill.
liquidator come with a audited statements, proper authenticated statement, then I will see. And come on the next date.
25.
This matter, I am appearing on behalf of the official liquidator.
My lord, I appear for the bank. My lord,
Yes,
I
Lordship,
was
on
granted
last-
liberty to take out an objection. My lord, I filed an application which is again, my lord, not listed today. My lord, CA 18 of 2025. I appear for the bank. My lord, I was given liberty to take out an objection. I filed an application stating my objection.
17. Who has filed 17?
17 is my application
17,
for
18
disbursement of money. On last occasion, your lordship has given
Now,
a
bank want to
direction
file
upon the-
objection.
Yes, my lord, I have already filed.
Objection
I have
or
already filed. My lord, I have an exception.
What is the amount you want to disburse? What is the scheme of disbursement?
Lordship.
Disburse a sum of rupees
4 lakhs, Lordship.
My lord, may I-
Present fund position is 456.
Yes, Lordship.
And you want to disburse 449.
Yes, and that 38 ex-workers are there.
What is the amount payable to bank? Where is that statement? Authenticated statement.
Bank claim is
Where is
there
that
about-
scheme of disbursement? This amount to this person, that amount to that person. Where is that scheme?
Lordship, I have stated in my summon for directions that leave be given to the official liquidator, High Court, Calcutta, to declare dividend 29.15%.
Where is the statement of accounts?
Yes, Lordship.
No
have
statement
not
of
filed.
accounts is filed. Authenticated statement of accounts must be filed by the official liquidator in terms of supplementary affidavit. Because you have not stated what amount is to be given to the bank. Where have you stated this?
No, Lordship, bank has not filed till today. They have not filed any claim till today to the official liquidator. That's why they have filed an application. That application is not appearing before your Lordship. On last
18 of-
occasion, your
All right.
Lordship has given a direction
That
to
is
file
what-
the claim before the official
is-
liquidator. All these years, they were sitting tight.
No, then
So
they will
now
not
they
get.
have come with this application.
Come with the statement of accounts.
My application will be listed on the next occasion, 18 of 2025.
Let the matter appear in the list along with CA number
18 of 2025.
18 of 2025 on 26th March.
Grateful.
I'm opposing this application for the official liquidator. And this application CS60 was also not served upon the official liquidator, my lord.
To the case, official origin side register. Yes.
I'm opposing this application, but this application has not been served upon the official.
Who filed this
liquidator.
application?
CS60 has
Yes,
been
who filed this? Mithua Shen. RIC
They were-
tenants.
Yes, my lord. Mithua Shen and one Mr. Bishash, both of them were appointed as a receiver with regard to collection of the rents of the property.
Joint
in
special
question.
officers.
Yes, joint special officers. My
Copy not served.
they have not served any copy, my lord, because they have
C-
made an
CA 60
application
of
for the
23.
discharge.
Is filed by joint special officers. Full stop. They are not present today. Copy is not served upon the official liquidator. The joint special officers shall be present in the court on the returnable day. Copy shall be served to the official liquidator, to the learned counsel for the official liquidator in the meantime. Let the matter appear in the list on 26th March.
27.
CA64, it's the same company in liquidation. Pursuant to your lordship's order dated 14 January, may I file the compliance report, my lord? There was a direction upon the official liquidator to
Compliance report is filed by the official liquidator. Let the same be kept in record. Let the matter
And-
appear in the list on
We have already, this is the compliance report and we have also made the payment, my lord. So nothing remains.
27th March for further order. I understand now the resolution order will be passed,
Yes, ma'am.
but you have to file along with the audited report under 281.
This is only for the payment of the security expenses, my lord. It's
Whatever that
nothing for
might
the
be,
dissolution,
for
my
final
lord.
resolution result, this is needed. This is the statutory mandate.
Yes, my
I
lord.
cannot
as per
even go by to
281.
this. An audited report, certificate of an auditor shall be filed on the returnable date under section 281 of the company courts rules. '28.
28, 29, and 30, they relate to the same company in liquidation. But I appear for the resolution.
Register original site কে? চার্জে কে আছে?
तुम्हारा बोल 28, 29, and 30 relate to the same company in liquidation. I appear for the resolution professional because parallel proceedings are going on before the NCLT, where I have been appointed in respect of the company in liquidation. Now, all the prayers in all these three applications are similar. The only the prayer, common prayer is execution of deed of conveyance in favor of the flat buyer.
Come on the next date.
Yes, but only one direction Lordship may pass again on me to file a report as to what to file a report as to the status of the flat in question. That's all. But this matter can be resolved. But all these matters can be resolved.
This is the report filed by the official liquidator as your lordship please to direct on the last occasion. What is the
Report of the official liquidator may kept in record. Adjourned to making a short date.
item number 79 and 81.
5th March.
5th month. Lordship will kindly direct me to file a report. File a report. I'll indicate all the details in that report.
Just
Kindly, in all
you
the
are
for the resolution professional.
The resolution professional, the learned counsel appearing for the resolution professional shall furnish a report on the next date on sale of the properties. Proposed sale of the properties.
Not sale, my lord. For execution of the deed of
For execution of the deed.
Just one submission, my lord. The report that
Come
has
on the
been
next date. I will hear on the next date. Next 29.
Your lordship, the report may be served on us.
Report may be handed over. Copy of the report may be handed over to the concerned councils.
Grateful.
My lord, not the three together. That's what I was saying. My lord, item 30, there is no direction on the liquidator to file any report.
28 and 29.
Yes.
30.
30.
Item number 30.
Yes, 30 is my application. Similar.
I'm seeking the same direction.
The
There is no
report
official.
is called for from the learned official liquidator.
No, my lord, that's not. My lord, on the resolution professional, kindly, my lord, directs me to file a report on the execution of the deed of conveyance.
Your lordship, item number 28 and 29, a copy of the report filed by the OL may be served on us.
Can't you hear this?
I apologize.
30. A report is called for from the resolution professional on execution of the proposed deed of sale.
I'm grateful. Grateful. May they appear on the same day?